Make these orders. But I have filed two requisitions relating to the tender process, my lord. And it is a construction work, my lord. And it was floated, my lord. And 26 2 p.m. is the last date of submitting the bid documents. Here, there is a condition in the NIT that bidders should visit the work site and take geographic photograph, and that photograph and a certificate should be obtained from the head of the institution that he has visited the site. But when the bidders went there, the head of the institution is the principal. He said that you get MLS recommendation.
Huh?
Local MLS recommendation. That is,
You are there. EWD.
no, it is about plain tribal affair. He is there, madam.
But I have not.
No, today I have filed, madam. So may I pay, madam, be agency is there.
EWD matter.
No, not PWD, my lord. It is a, my lord, WPT and BC department, madam. Plain types department.
Maybe corporation.
No. It is a corporation, my lord. Assam Plain Types Development Corporation.
Don't construction corporation.
Corporation.
A. Sharma. Ukshuman Sharma. Ukshuman Sharma.
Well, I will inform him, madam. Matter will be taken at 2. Because, my lord, it is an extraneous condition, my lord. Why MLS recommendation is required for getting that certificate? And without that certificate, we cannot submit the, my lord, to favor some, my lord, bidders, my lord. They are doing. So, my lord, at 2, my lord.
May I please, Your Lordship? I beg to mention.
May I plead the Lordship, my lord, I pray for listing of a matter on Tuesday, my lord, motion matter, my lord. My lord, urgency is there, urgency is that, my lord, once the work has been cancelled with the private respondent. And that the private respondent approached this honorable court, and this honorable court held that the termination is not liable to be interfered with. Now, subsequently, my lord, the authorities have issued order to that private respondent, allowing him to resume his work, my lord. Whereas this honorable court has already held that his termination is not liable to be interfered with, my lord. Obliged, my lord.
So when?
Tuesday, my lord.
Why?
Because he has been asked to resume the work immediately. So any moment, my lord, he may resume the work, my lord.
If he does. So how does it matter? If he does, how does it matter on Tuesday?
My lord,
Will be
before the resumption, if it can.
Wednesday. No thing.
Obliged, my lord.
May I please, Your Lordship? I beg to mention item 36, Lordship. I beg to mention item 36, Lordship. I need some time to file additional affidavit in this petition, Lordship, on behalf of the petitioner.
Why?
There's one appeal has been filed before the division bench, and honorable court directed to file additional affidavit, Lordship. In this, so I need some 1 week time, Lordship.
Yes, ma'am. Yes. Yeah. That writ appeal was dismissed. But honorable division bench has given them a liberty to bring whatever they had to say before this court in and confirm additional affidavit. That
No, then also I took up the matter that
Yes,
day.
my lord, yes.
Then what is there? You have not filed your additional affidavit.
No.
Is there stay? No stay.
No,
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 sir, no,
no,
sir.
No stay.
No,
nothing.
So have you thrown him out?
Investigation is going on, madam.
No, that you go
Yes.
ahead, put him
Right.
behind the bars, but
Yes.
have you thrown him out?
No,
Have you thrown him out?
He's still in school.
Huh? How is it possible?
So 1 week time to file affidavit, Lordship. 1 week. Let me bring the trick. 1 week time.
My lord, in the meantime, I also got some documents. So everything I will bring on recording by Wednesday.
At the request of both the council, Mr. H. Talukdar.
KD Sharma.
KD
KD sir.
Sharma seeks time to file an additional affidavit. Mr. Ardhar also submits that he would also file an affidavit. List this matter only after the additional affidavit as well as the affidavit is filed by the WPT department.
Master.
May I please, Your Lordship? My lord, with the consent of other side, my lord. I'm for the writ petition. My learned friend is aspirant number 5, my lord. Yes, file my lord affidavit in opposition. My lord, I have to file my lord reply. A little time may be given, my lord.
How many weeks?
My lord, only 2 weeks, my lord.
Item number?
Item number 53, my lord. Supplementary admission.
Is there a stay?
No, stay, my lord.
At the request of the learned counsel for the petitioner, the matter stands adjourned for filing affidavit in reply. List the matter only upon filing of the affidavit in reply.
Yes, your lordship. Lordship, in respect of item number 38, lordship, we have filed additional affidavit, lordship, that may be called for that. Yeah, I know.
May I please, your lordship? Lordship, in regards to item number 27, my lord, as directed by your lordship, we have filed one affidavit in opposition, my lord. So that may be called for, my lord. Mobilize.
Yes, Mr. Sri.
Lordship, I'm appearing on behalf of SMED for the petitioner. We got instruction that she have got the relief, the petitioner have got the relief. So we want to withdraw the
Which item? 41,
item
na?
41, yes.
41, my lord, this is contempt actually. Cannot be withdrawn. It can be, cannot be withdrawn, discrimination closed. But she is also not in this case, I think.
You are there, A Google?
No.
No, Lordship, I'm appearing on behalf of SMED for
Oh.
the petitioner.
This is, but
Let the matter come.
yes, particularly contempt, otherwise you don't.
I may drop it.
Lordship.
With regard to item number 39, madam, government have filed the affidavit, madam. We need to file a reply, madam.
Stay.
Stay is there.
No stay, no waiting. We'll see when the matter reaches. When did they file the affidavit?
Madam,
We have brought that,
Now, when did the government file the
on
affidavit?
2020.
20?
They, as per the earlier order, madam, they were supposed to file it on 18th. But they have filed it on 20th, madam. We need to reply that, madam.
We'll see when the matter reaches.
Motion item 1.
Conception, due date pending since long.
Which department? Water resource.
What?
Why you are not making the secretary government of Assam? Water resource department a party? Things will move then only. Anybody from water resource? Nobody. As water resource matters in emotions. Mr. Council, you just wait for some time. Let me get hold of our water resource council. Then I'll pass on this.
Item 2.
Same,
2 and 6 same.
we'll take it.
Item 4.
You in the meantime search Miss Ardeka. Yes, find her. Yes, where is the petitioner in person?
Can you for the matter for the time being, man, she's coming.
Oh,
K Fukon, London CGC, K Fukon.
yes, tell me what has happened in the meantime.
Your Honor, this is like, while hearing this matter, just after hearing this matter on last occasion, the respondent number 4 had accepted transfer of my institute at Odisha. So this is the case.
But I think you need to file a fresh writ petition.
I have filed additional affidavit
Yeah.
also.
You have to file a fresh writ petition challenging the transfer. additional affidavit, by additional affidavit, you cannot challenge it. As you are a petitioner in person, therefore I am guiding you. So therefore you need to file a fresh writ petition challenging the transfer. Okay? You withdraw and with the liberty to file afresh by challenging the transfer.
I will file it, Lordship, but till then, this operation may be at least,
That is not the subject matter of the writ petition. So you need to file a fresh one, challenging the transfer, and then only I can stay that. Okay? Mr. B.S. Lockhart, the petitioner in person, submits that pursuant to filing of the instant, that on when did this happen, the transfer?
13th of this month.
On 13/8/2025, comma, the institute which the petitioner in person owns and in respect of which he was the, what was the term?
Accountable manager.
Accountable manager, have been transferred by the DGCA
By the DGC.
to another, to a place at Orissa. And as such, he would like to withdraw the instant writ petition without prejudice and would like to file a fresh writ petition challenging the actions which is also the subject matter of the present writ petition along with the subsequent events. Taking into account the above, comma, the instant writ petition stands closed on withdrawal. Full stop. The withdrawal of the instant petition shall not prejudice the petitioner to assail the to assail the subject matter of the instant, which is to assail the actions of the respondents, which is the subject matter of the present writ petition, as well as challenge the subsequent events. A. Pukani on behalf of the respondent.
Item 5,
A.L. Borbhuya, what?
Non-payment of higher
You are appearing for
All month.
notice issue কৰিবা আগৰ খিনি উপৰখিনি ক'ত কি আছে এইবোৰ চিম্বল চিহ্ন। We have it on 8th of December. Affidavit to be filed by 1st of December.
6,
আমাৰ এটা আছে ন? What is this?
Outstanding bill.
Contractual bill.
Outstanding bills. Yes, BTC, why you are not in a position to pay? You have a lot of money.
No.
No, you are, I could see issuing contract to certain persons at a much lesser amount for the purpose of
My lord,
other
few
things.
events that
Yes.
like regarding market, my lord.
So market, so why, what is your problem?
Please, no, my lord, Lordship will issue notice, my lord, in the meantime, my lord, because funds come from the state of Assam. This week's, my lord, 800 crores.
Own resources where you can get money, you are not bothered. Or are you too much bothered on what Mr. B. Gogoi is going to provide, being the finance council?
This is Lordship will issue notice, my lord.
Eto eya koi dibo, ha?
I appear for number 4 to 10.
1, 2 and 3, huh?
4 to 10 I have.
We'll have it on 8th of December.
As well as 10 and 11. No, no. 1, 2, 3, 10 and 11.
We are having it on 8th of December, notice returnable on 8th of December, filing of affidavits by 1st of December. This is enough time.
Lots. But item number 7 and 18, same, my lord. Same petitions. 7 and.
You are the same council.
Same.
Obviously.
item 9,
May I please, your lordship, my senior is out of station. Please adjourn for the day and set the matter to 27.
Council, where is your work order?
Work order is not annexed.
Where is your supply order? You can't file this petition like this. Let your senior come. When is he coming?
27, fix this matter on 27.
Huh?
Fix this matter on 27.
No. Today, when is he coming?
He is
I'm
out of
dismissing
station.
right away. Why did you file the motion when this court is sitting? You have taken the advantage. I'm not sitting for next week.
My lord, he is
Why
out
are
of station for
File
medical
the
emergency.
day.
My lord, he is out of station for medical emergency. He went to
So
Calcutta.
you argue, how on earth can you file a petition asking for money without the work order or the supply order?
Actually, I don't know.
So on this ground, we dismiss you. You withdraw with liberty to file enclosing the supply order. Better off. Otherwise, I am dismissing.
Then you can come again.
Please, liberty.
Ah. The instant petition has been filed by the petitioner seeking non-payment of dues in respect to certain supplies made by the petitioner in the year 2000. My goodness, 2011. No. This also liberty also not permissible.
Please, my lord.
No. I'm going to dismiss it right away. This is not a case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. R.K. Talukdar. R.K. Talukdar.
R. Talukdar, Lordship.
R. Talukdar appears on behalf of the respondent number
respondents.
1 and 3.
Lordship.
None appears for the respondent number 2 when the matter is called. The petitioner herein has filed the instant petition claiming that he had not been paid for the works done by the petitioner, and in respect of which bills were issued by the petitioner on 3/4/2011. Full stop. The petitioner have neither cared to bring on record as to whether any supply orders were issued, or any supply orders or work orders have been issued in favor of the petitioner. Further to that, it is astonishing to note that the petitioner is asking, has approached this court after a period of 14 years from the date on which the petitioner purportedly, allegedly issued a bill on 3/4/2011. First, this court further takes note of that the petitioner have sought for a writ in the nature of mandamus, but have not. This court further takes note of that the petitioner had submitted representations in the year 2018 and 19, and after a period of 6 years from the date of the last representation, the petitioner has approached this court. Full stop. It is the opinion of this court that a belated claim if sought to be agitated by filing a writ petition, and any notice being issued directing verification, and again, it is the opinion of this court that belated claims like the present one, if entertained, is not only an abuse of the process of the court, but would also impact upon the defense of the respondents, inasmuch as it is inconceivable that the respondents would be maintaining any records for a period of last 14 years. Consequently, this court does not find any merit to even issue notice in the instance proceedings for which the same stands dismissed. Taking into account that the counsel, the senior,
Left out at mate.
Lordship, here petitioner supplied materials for construction of raised platform, my lord. Page 37 is the supply order.
you supplied.
I have supplied.
Then
Work is completed. Work is completed.
payment not made.
Payment not made. Well, 2020 to 23.
Good. You have accept notice on behalf of whom?
Respondent number 2, 4 to
A
10.
union is who is Union of India? Union, we can put K. Phukan, I saw her somewhere. K. Phukan of the River, Union of India, Panchayat N. Bora. And then all others you are appearing except
Noted for 3, I will be appearing. I have to look at for respondent number 3.
3, remaining you are appearing.
That's it. 4 to 10. That's it.
This is made returnable on 10th of December. The filing of affidavit by 4th of December.
Item 10.
Yes, wait. 123. 120. Madam, where is the 123 person? Madam, here are cases where contempt, I normally in a contempt jurisdiction, I don't issue notice first because it becomes, once you issue notice, for dropping it becomes very difficult. I cannot allow them to withdraw unless you comply. So therefore, my normal thing is that I ask the standing counsel to take instruction as to why it has not been complied and give an opportunity to comply. If you don't comply, then I'll issue notice. Okay? We take to the silent item number 1. The petitioner herein has approached this court by filing the present contempt application alleging willful and deliberate violation to the order dated 27/11/2024 in WPC number 8406/2022, whereby there was a direction to make payment to the petitioner of the admitted dues within a period of 3 months from the date of receipt of the certified copy. Full stop. The petitioner thereupon, on 2024, have duly submitted the certified copy to all the respondents in WPC number so and so. However, as even after a passage of 3 months thereafter, no payment have been made, the petitioner has therefore approached this court by filing the present contempt application. This court, before issuance of any notice, deems it proper to inquire as to why the order dated so and so, passed in so and so, have not yet been complied with. Accordingly, this court have requested Ms. Ardeka, the learned standing counsel of the Water Resource Department, to obtain instructions as to whether the order dated so and so have been duly complied or not. Full stop. List this matter again on 15th of September 2025. An extra copy of the contempt petition be served upon Ms. Ardeka, the learned standing counsel, so that she can obtain necessary instructions. Full stop. The name of Ms. Ardeka be reflected in the cause list in respect to the present proceedings. 3. All these three. Same matter.
Same 1 to 3.
So he got an excited. You obtain that instruction so that if it is complied, and this time I am giving, which is another 30 days or 20 days,
Yes.
is for your compliance.
Yes.
Item 10,
Yes.
Petitions of-
When Mr. Nair stands, I know the other side would be Mr. H.K. Das. Yes. What is this?
My lord, this is for selection and appointment to the post of head assistant in the CJM's establishment, Majuli, my lord. My lord, the requirement is 10 years of service as UDA. My
Yes.
lord, as UDA, upper division assistant. My lord, the respondent who has been selected and appointed, my lord, he was promoted to UDA in 2019. And the selection was in 2024. He does not meet the eligibility criteria.
5 years.
5 years. The criteria is 10
For
years.
this
my lord.
5 years, they relax it, na? They, in terms with
Yes, my lord.
rule 12 or
Rule 16.
64.
Yes, my lord.
No, to
This is what they do.
my lord. My lord, in the advertisement at page 41, my lord. My lord comes page
Rule
40.
17, my lord.
No, to-
No, no, I got it. 17 of relaxation of power.
My lord, page 41. The qualification eligibility, my lord. Candidates having 10 years of experience in service as upper division assistant.
Yeah,
continuous-
17. They exercise 17.
My lord.
Yes, that instruction I'll have to have. Moreover, this is the promotion of January, my lord. This is-
Recruitment. Of course,
Sorry, my lord.
some delay
Still
on
okay.
my part, my lord. That is there. my-
Anyways, don't worry. We'll finish it off by 18th September. The matter will come to an end.
My lord.
We don't need to issue.
Fine.
Issue notice making it returnable on 18th of September 2025. Mr. Ms. Yudas accepts notice on behalf of the respondent numbers 1 and 3. Mr. H.K. Das accepts notice on behalf of the respondent number 2, 4, 5, and 5, 6, and 7. Extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 8, the counsel for the petitioner is directed to serve an extra copy upon Mr. H. Das,
HK Das.
H.K. Das, the learned standing counsel of the Guwahati High Court, so that he can so that service can be effected through the respondent number 6,
Yes.
and in whose establishment the respondent number 8 is presently serving employed. Full stop. The registry shall submit a report on the next date. Extra copy during the course of the day. Full stop. The petitioner hearing have assailed. Where is the assailing order?
My lord, annexure 10, my lord, and annexure 6. That is page 46 and 47. 46 is the result, 47 is the notification.
And
47, 46, 47.
what is your name?
I am my lord Pankaj Kumar Das.
You got 31,
I got 31 and he got 38. I'm the second there in the results sheet.
but you are junior.
I'm senior, man. I'm senior. I have 20 years of
This
service.
is a recruitment process, the criteria is selection, my lord.
Huh?
In the recruitment process, my lord, criteria is selection, not seniority cum merit. As per the rule.
Is it
Yes, my lord. If your lordships kindly consider the rule,
6?
rule 6(1). Head assistant by selection from amongst UDA with so and so service has such to their credit, including supervisory assistant in any chief judicial magistrate establishment ministerial.
Right? How do you carry the selection?
My lord, written test and advertisement itself specifies, my lord.
Page 41. There's a
Now,
skill.
thereafter, the civil shall forward the recommendation of the select together with the character
character
roles and
roles.
other concerning
Yes.
the application to
Yes.
the district and session judge concerned, who shall make the selection strictly on merit and make the appointment. So it will be merit, no?
Merit.
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 The petitioner herein is aggrieved by the appointment of, by the promotion of, appointment, is the by the appointment of the respondent number 7, 8,
Eight, man.
as the head assistant in the establishment of the Chief Judicial Magistrate Majuli, on the ground that the respondent number 8 did not have the requisite 5 years, 5 years,
10 years.
10 years of service, which is one of the conditions for eligibility in terms with Rule 6(1) of the Assam Chief Judicial Magistrates Establishment (Ministerial Service Rules 1987). The learned counsel appearing on behalf of the petitioner submitted that the respondent number 6 now,
6.
ought not to have invited, or ought not to have even invited the petitioner, respondent number 8, ought not to have permitted the respondent number 8 to participate in the said selection process. Full stop. The learned counsel further submitted that the question of relaxation of Rule 17 of the rules of 1987 also do not arise, taking into account that there were already eligible candidates. Full stop. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, submits that he would obtain instructions and also place the instructions as well as place the records of the selection minutes on the next date. So, taking into account the above, this court directs the respondent and directs the respondents to bring on record their stand by filing their affidavits. This court for the Mr. P.D. Nair, the learned counsel appearing on behalf of the petitioner, submits that the order of appointment of the respondent number 8 being contrary to the rules of 1987, the said order ought to be stayed. Full stop. This court, for the time being, is not inclined to do so. However, on the next day, if no affidavit is being filed on behalf of the official respondents, this court shall duly consider the same.
Deeply obliged.
Highly, much.
11,
Your lordship.
My please, your lordship. Kindly pass over the time being. Senior counsel will argue the case.
Number 2,
Adjournment, your lordship.
this is also adjournment.
Time being, he is election code number 1, your lordship.
Has issued an impugned letter whereby the petitioner is informed that the lease is supposed to be cancelled due to dereliction of duty and failure to maintain safety protocol. Subsequently, on demand, the respondent number 2 had passed the whereby the lease granted have been cancelled for operating the remand on the ground of negligence. Chalo?
He will come into time being, your lordship. Obliged.
12,
Yes, Mr. Ghosh.
My lord, here I am, my lord, against an re-tendering process, which was, my lord, issued on
1/8.
1/8/2025, my lord.
And
Because
what
I've
is the
already
last
participated-
day?
Yes.
What is the last day?
Last day is today, na?
Opening of.
Today is one of the last days for me.
Then, have you participated?
No, my lord, I have participated in earlier process, my lord.
Now, have you participated in the fresh process?
No, no, my lord, because
That is to your peril. Okay, now let us start.
my.
Yes, what is it? What
My
is
lord,
that?
Now, my lord, first NIT was issued on 5/9/2024, my lord. It is a two-bit system, my lord. I participated along with my lord.
5/9/2024. Then,
Then, my lord, my bid was accepted as L1. Technical evaluation was done, financial evaluation done. I was at just L1, my lord. And my lord, on 7/3/2025, page 22, my lord, letter of acceptance was issued, my lord. So it is tantamount to formation of a contract as per their terms and condition of NIT, my lord. And I have asked to deposit a performance deposit, which I did also, my lord.
then,
My lord, as per my instruction on 18/3/25, my lord. So the departmental engineer visited the site after getting and possession was also handed over to me on that day, my lord. So that thereafter, my lord, the matter was not, nothing was forthcoming, my lord. So I opposed this honorable court by filing a WPC, my lord. For issuing on the formal word order, my lord. Then, my lord, they come up with a plea that my lord will find at page, my lord, the 29 of the order. Para 6, lordship. Well, no notice, nothing was communicated to me.
then,
My lord, suddenly they came with a new, my lord, retendering.
so what is this? Page 30?
Page 30, my lord, in order the formal communication of the decisions. No decision, no communication was made till date, my lord.
You have not done?
That minute I will have to have the inspection. At 2, got instruction I can have.
Huh?
At 2 I can have it. Otherwise, my lord, the tender was issued on 1st of August. On the last day, he has come up before this honorable court. Should have come earlier, my lord.
My lord, there is nothing, if your lordship,
Even that-
they are instruction, my lord. There is a bird and wild delegation, no specific, nothing, my lord. My lord, decision is holding the field. Because they said, my lord, they'll giving it someone else from the, my lord, earlier process. That they abandoned, no notice was given to me.
And in the, my lord, it is near no cancellation notice, nothing, my lord. All on a sudden they are coming with the retendering. My tender accepted, site was handed over, therefore all on a sudden, my lord, this development happened.
But Mr. Gugoi, one thing is very important. If without complying with the order passed by this court, if we have proceeded, then I think it is not fair. So the only, if I put it at 2, the period is over, the closing is happens.
Yes. If at all some order is passed, my lord, even as service, my lord, you will not get the opportunity, challenge it.
So either you issue a corrigendum, thereby extending the
Extend it.
period,
Hmm.
the closing. I think that is the.
Yes,
best way.
instead of staying in the process, my lord, it will.
Then we can look into it. You
Yes.
see, the question is not there, but I think he should be allowed to participate.
That liberty lordship will give, my lord, without prejudice, let him participate in this process.
No, there is no period. I will ask you to extend.
Lordship.
Why should I put this matter, keep this matter pending? And tomorrow if I decide, if he participate, there is again multiplicity.
My
You
lord,
bring in many aspects.
lordship,
So
lordship,
instead of extending it by 7 days, if we
Right.
can extend it by 7 days,
lordship.
let him participate. You gave us, you see, the reason is the order which has been passed by this court
Lordship.
is on the basis of an affidavit being filed by you.
Yes, yes.
Affidavit not filed.
No instruction.
In order
In
to
written
avoid
instruction.
delay, kindly come
Yes.
to page 29.
It is a
On
written
account
instruction.
of avoiding the delay and all, you will be going for engaging another eligible bidder from amongst the original qualified tender participants in accordance with the terms of the procurement norms. So now you want to go.
Right.
Now, at that point of time, he knew it. He asked for it, you are not going to give. It is
Lordship.
the only thing that you had to give him an order.
Lordship.
If you have not given him an order, going ahead could be in
My lord,
violation.
I understand.
So better off, let you obtain the instructions. by-
After some time, my lord, yes. After some time, my lord, I can come up. I have already sent the order, my lord, to them.
Well,
Oh, yes.
and to that effect that you are going to issue a corrigendum, granting another 7 days for submission, and then we close. Nothing more than that. Let him participate.
Lordship.
I'm not going to, with your wisdom, you can go ahead,
Lordship.
but let him participate. You cannot do it. Although he has come at the last time, but he has filed a writ petition. It has not been listed, it's a different thing. When did you file the writ petition? 18A. So he has filed he should have filed it early.
My lord.
But he must have come to that Mr. Ghosh, and you know Mr. Ghosh is otherwise a very busy counsel. He doesn't have the time. I think
My-
that would be more fair.
Yes, my lord. I-
So that the tender process is not stalled. You get your instruction by.
My lord, actually, I challenge the propriety of this.
No,
you are,
nothing to it.
data.
Then I will dismiss everything. You participate. Only thing I am going to that he is coming up with an instruction that in view of this, they are going to extend it by 7 days or 6 days. In the meantime, you can participate. I'll close this petition on the basis of that.
Timing at 11.
I have to do it before 12. The order has to be passed, dusted, everything by before. Yes, Mr. Sekia.
Sorry, my lord, could not be present at that time, but no, here, my lord, I was settled with the, my lord, ferry service, and which is valid up to 31/3/2026. Now, because of an incident of capsizing of a boat, my lord, 3 persons had died. And my lord, a so-called notice was issued to me, my lord, on 19/6/25, but you will find it at, my lord, page 41.
And it has been? You have submitted a reply
I have submitted my reply.
and they did
specifically-
not find it good,
They did not-
satisfactory.
No, they did not consider it only.
No, they say here at the Alexa 10, you were issued a show cause that however the reply submitted by you was
Which,
not be.
was
not
not
to
what
be
contributed.
not satisfactory.
Nothing has been mentioned, and the ground of, my lord, you will see the ground of, my lord, under which, my lord, they have cancelled the last paragraph. In view of the above, in the exercise of the relevant clause 6, 11, and 14 of the lease agreement, it is hereby informed that your lease is proposed to be cancelled due to dereliction of duty and failure to maintain safety standards. Now, my lord, these clauses are at page 27. It has nothing to do with the, my lord, the allegation that has been, my lord, sought for my reply in the show cause notice. This serial number 26 at page 27. Page 27 is the clause 6, my lord. Three clause they have invoked, my lord. The lease shall bear the expenditure on pay and allowances of the floating staff allotted by the department for any type of boat vessel placed at the disposal of the lessee during the.
No, kindly see annexure 7. That's the show cause notice. Show cause notice is there.
Yes, so.
Negligent operation of ferry, endangering human life and all these things.
My lord,
Absence
this,
of live equipment and so on.
my lord, the
Anyway,
violation.
Mr. Soika, we can only issue a notice, nothing more than that.
No, my lord, will kindly see, my lord, this.
No, this could.
Lord, this is
because,
a private boat.
Let us assume today that I grant a stay and thereby you are running. Tomorrow you withdraw the petition, then what happens?
No, I'll not withdraw, my lord.
Not possible.
No, my lord, lordship will kindly see, my lord,
Not
at least, my
possible.
lord.
That day I saw one matter, one of the councils, he obtained the stay from the court in the year 2021, stating that, look here, this, my period is up till 2022. They have given me asked me to vacate. And the court says, don't disturb him. And that interim order continues till 2025. And he run beyond the period also. Nothing big.
No, my
We'll
lord,
issue-
no,
no, we,
my lord,
Mr.
just, my lord,
Saika,
only, my
we
lord.
will issue a short notice asking them to file their response.
My lord, that will be, my lord, day after, my lord, time will be taken and then, my lord, the process, my settlement is only up to 31st, my lord, March 2026.
Don't worry.
I have deposited the amount, my lord.
Don't worry.
Now the
You will
grounds.
be entitled to refund if that be so.
My lord,
If your cancellation is bad, then you will be entitled to refund. It is only the question of money. It is only the
Also,
question
my
of
lord,
profit.
my lord,
There's nothing else.
it has with the, my lord, livelihood also, my lord, not only me, the staffs, my lord, I have deployed, those are also concerned.
You should have known it before the accident happened.
My lord, here the boat that has been, my lord, met the accident, it is a private boat, not the government, which were entrusted to me, my lord. And lordship will, in the show cause, my lord, they said, my lord, that this particular, my lord, safety measures were not taken. In the reply, I said, this is your duty. It is not my duty. So therefore, they don't, my lord, consider my reply at all. And now they have invoked these clauses, my lord, 6, 11 and 14, which has nothing to do with the, my lord, allegation made in the show cause notice. So far as criminal case is concerned, their FIR has been lost, that is already pending, my lord. In fact, I was arrested also there.
Sure.
Well, the specific, my lord, in 41, your lordship will.
Where is annexure D of control of ferry rules? Enclosed to the petition?
SOP.
No, not the SOP. The lease agreement. Where is the lease agreement?
Yes, that is, my lord.
Annexure D.
My lord, that's what, my lord, I'm referring to, my lord, agreement, my lord.
Where is that?
Page 27, my lord.
Annexure D. Where is annexure D?
Appendix D, annexure 4, my lord.
Where is that? Here it is.
Page 27.
Page 6.
Page
Shall
27.
bear the expenditure on pay and allowance of all floating so and so, so and so. 11. Approach road of area constructed and so and so. 14. Shall provide and maintain the lighted zones and light on each one so and so.
Incident happened in the morning.
Mr. Soikia, you have not been running the ferry from
20th of June
2025.
25.
So how? What heavens will fall? Ask them to file a year. Nothing is in. You have not been running. Today you want a stay so that you can run. A termination order being stayed. making the dead walk. No.
My lord, in that case, my lord, what my
Notice.
suggestion, my lord, at least, my lord, on that day, matter can be disposed of or otherwise, my lord, considered by interim payer on that day on filing of the, my lord, otherwise, my lord, the routine, my lord, the next
I
day.
can't take the responsibility of my brother judges.
that is-
I can only take the responsibility if I am there. I am not here for 2 weeks, so I can't take it.
Lordship, there's hardly, in fact, totally, there's hardly any left to be argued, my lord.
We'll hear it again. Let me fix it on a day when I'm coming back. But issue notice making it returnable on 10th of September 2025. You are paying for?
My lord, MD Bora for all the respondent, MD Bora semi recorded, my lord. She's on Lexington Court one.
Respondent numbers,
All the
Mr. Swell, so appears and accepts notice on behalf of the respondent numbers 1 to 4.
My lord.
The petitioner herein, extra copies being served upon him during the course of the day. The petitioner herein, the petitioner herein was issued, was granted a lease, was granted a settlement of the Larkuchi Mazorsar ferry service for the period from 2024-26 by the respondent authorities. The petitioner had also duly paid the KISS money, no? Mr. Singh? KISS money. Pusto. On 19/6/2025, an incident happened which resulted in fatal consequences. Pusto. Subsequent thereto, the petitioner was not permitted to run the ferry service with effect from 20/6/2025. Next. The petitioner thereupon was issued a show cause notice on 16/7/2001. 2000? What is that? On
19/6/2025,
19/6?
2024.
Where do I get the date?
Or page 41.
19/6/2025. As to why? Appropriate action shall not be taken against the petitioner on account of the lapses indicated in the said show cause notice. The petitioner immediately on 26/2025 submitted the reply. And further, on 7th of further, by another communication, the petitioner requested, submitted its reply. There was no decision taken in respect to the so-called notice. And as such, the petitioner filed another representation for allowing the representation on 7/7/2025, allowing the petitioner to run the said ferry service. Subsequent thereto, on 2/8/2025, 2/8/2000, the petitioner was duly informed that his reply to the show cause notice was not satisfactory. And it was further informed that the lease of the petitioner was proposed to be cancelled. On 4/8/2025, the said lease was accordingly cancelled by the impugned order. It is under such circumstances the petitioner has approached this court. Mr. P.J. Saikia, the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner, submitted that there is no violation committed by the petitioner as would be very apparent from the allegations made in the show cause notice and the reply so submitted by the petitioner. First, mechanically, the respondent authorities have rejected the said reply as not satisfactory. First, he further submitted that the violations which have been alleged in the show cause notice are not the reasons for the cancellation, and therefore submitted that the action on the part of the respondent authority is not only high-handed, but also suffers from gross unreasonable, grossly unreasonable, attracting the mandate of Article 14 of the Constitution. Ms. M. Deborah, the learned senior counsel, therefore submits that the impugned order by which the petitioner's ferry service have been cancelled is required to be stayed, and the petitioner ought to be allowed to operate. Per contra, Ms. M. Deborah, now you are appearing.
Lordship, I'm sorry, Lordship, I'm late.
Ms. M. Deborah, appearing on behalf of the Transport Department, submits that the reasons which have been submits that there was an accident which led to a fatal consequences, and from the tenure of the show cause notice, it is apparent that the petitioner have failed to comply with certain requirements. The learned counsel further submitted that although she doesn't have the entire instructions, but from the perusal of the show cause notice as well as the impugned order, it appears that the same is based upon the said show cause allegations contained in the show cause notice. She further submits that the respondents would be filing an affidavit bringing on record their instructions. This court, having heard the learned counsels appearing on behalf of the parties, is of the opinion that as the lease have already been cancelled, passing an interim order at this stage without giving an opportunity to respondents to provide the instructions would not be fair, would not be in the interest of justice. However, this court cannot also be unmindful of the fact that if there is any fact that the petitioner have also alleged violation of Article 14 of the Constitution. Consequently, this court fixes the is of the opinion that this court therefore fixes the matter on 10th. Fixes it on 10th.
Lordship, can it be 11th, my lord? 11th.
11th.
Lordship, so many.
Day?
No, Lordship, there are some other part of matter on 10th. So 11, my lord. I will file affidavit for it.
On 11th of September at 2 p.m.
Lordship.
It is observed that if the affidavit in opposition is not filed, bringing on record the instructions by 5th of September, this court shall consider passing interim orders.
I will file, my lord.
That is your look.
I'm so deeply blessed, Lordship.
Item 13,
What is this? Non-payment.
Non-payment matter.
You are appearing for all?
All.
No finance?
No finance problem.
Why you are not making the finance a party?
Necessary party.
Tomorrow, what will happen? What is going to happen? I will pass an order that he should verify and pay. Then they won't pay. Then you file a contempt. When you file a contempt, then they will say, "Then look here, we are ready. We verify. This is the money. Finance is not giving the approval. What is going on?" Then it cannot be complete. At the end of that, answer. Think what to do. What do you want to do?
Notices may be issued, in the meantime, we will seek instruction.
For impeding. At the end of the day, this is going to happen. Unless you take care of the irrigation department. Okay, except for the notice condition. Available on 15th of December 2025. Affidavit be filed by 5th of December 2025. Liberty given to the petitioner to file reply by 12th of December 2025.
14.
What is Forest Brahma? I saw similar matters out there. Oh, it
Yes,
is
Lordship.
another.
It is hard matter, Lordship.
Yeah.
Lordship, page 29 is not legible, Lordship. Comparative statement.
By equity market, the petitioner is the highest bidder. Official bid was 37,247. And my client bid was 1,25,000. And the respondent number 6 bid was 1,152. But settlement was given to respondent number 6. Here also the draft has been submitted in the name of his friend, my lord. Was the
Lordship, I took instruction.
Oh, this order will have to be same with that order.
Lordship, draft is not submitted by him, Lordship. That is why cancel, Lordship.
Huh?
Draft is not his name, Lordship. That is why cancel, Lordship. Draft, bank draft. And
Yeah,
Lordship,
bankrupt is there. Bankrupt is there.
not.
No. Madam, there were two cases
Yes.
of Mr. Forest Brahma. First was the case which is exactly similar like this, where I granted a stay. Whereas in the second case, where he gave the draft of his brother, one Bishitra Brahma,
Yes.
isn't it?
Yes.
That is in respect of another market. That is a tender of 8/5/2025. This is of 7/6. Yes, 7/5. This is of 7/5. And there, I think this is 12. This is the highest bidder.
Lordship, kindly see page 18.
Huh?
Page 18
Of
of writ petition.
tender.
Writ petition. Page 18 of writ petition.
Ah,
Draft is given by Subal Ramseri.
oh, same. So the second order will apply.
That is page 18.
And Lordship, document also.
Whether that was issued in the name of the principal secretary or not. They have to receive the amount only.
No, then obviously we will look into it. No. This cannot be the document. This the document. No. You see, this cannot be the document. Kindly come to Annexure 3.
Annexure 3.
Draft number
Annexure 3.
534167.
And accept it like this.
On a comparative statement, one thing I beg to point out.
That is, wait, don't worry. Draft is 534167. You see that?
Comparative statement is not legible, Lordship.
You give a better copy.
The comparative statement, my lord, my petition is the highest and he is the
Is 167. Here the draft
That
number
number,
534172.
151, it is the respondent number 6 and the number 2 is the petitioner, 1,25,000. My lord, below the note given by your lordship, I kindly see the note because they have not rejected the bank draft. It is evident that they in the the defendant 1, 2, and 3 has offered the bid money above the government, and they have submitted all the necessary document and they forwarded to the market settlement committee.
Lordship,
So
I have,
regarding document, they have not raised any objection, my lord.
Lordship, I have
That
obtained
they
a
have
comparative
ID,
statement in WhatsApp,
draft
Lordship, from the
written
authority,
down.
Lordship. Here, remarks follow
No,
no
but
draft.
it will be the second order, Mr. Counsel. This is 172 is the second order. His second order to do the orders. One is stay, I took the stay line. The second order will fail. will be the second order. As regards the draft, also given. Here there is the draft is of a different person. 534172. That is the reason why it has not been. 1, 2, 3 has offered the bid value above the demand. So they have given it to respondent number 8, huh?
Yes.
No stay. When did they fix the other matter?
15 September.
When?
15/9, my lord.
15/9. Same. Plus 10. That's order. The first that I. Enbora IPS for PNRD. You are appearing for district.
Second order administrative.
DC.
4, respondent number 4.
And he.
I'm 235. Complaint.
It will hit second order. First order to stay at Ekuno.
I think 15.
Please, your lordships. This is, this pertains to a notice inviting.
Just 1 second. Lordship, if the lordship accept the matter on Monday next, you can file an affidavit, entire instruction.
So Monday is a holiday, and last date, may I just open the matter? This pertains to a tender which is for installation of lifts. This tender has been restricted to only 5 manufacturers, and they have been named. Your lordship, may kindly go to page 29 for a moment.
What are you asking?
Because I am asking that this is an open tender and everyone should be allowed to participate. Because at page 29 bottom, your lordship would kindly see qualifying criteria for participation in tender. Page 29, your lordship has. It says only the following brands are eligible to participate. So all foreign brands have been noted: Kone, Otis, Schindler, Mitsubishi, Hitachi, Fujitech. Plus thereafter, your lordship would also see the other conditions are also not been satisfied by these brands which have been listed, like they should have a local office over here. Now Hitachi and Fujitech do not even have offices over here. And this issue, Mulaz, in so far as brands is concerned, I am only concerned with the brands being listed, Mulaz. The Honorable Supreme Court has also clearly held in my matter only that, Mulaz, these brands cannot be listed, Mulaz. You cannot list brands by names and restrict the tender only to such brands. Supreme Court also says that around 18 high courts have also.
The Supreme Court.
Please, I'll take page 174. Your lordship may kindly see.
74.
This is Omega Elevators versus State of MP. Your lordship may kindly go to paragraph 8, Mulaz. The short question, however, that survives for consideration is whether GMC, it is Gwalior Municipal Corporation, decision to restrict bidding process to only 10 companies and thereby exclude all potential bidders can be justified in light of the precedent cited above, and whether the High Court correctly applied the ratio decisionality of that decision. We have heard the learned counsel of the parties and mindfully peruse the record. The legal principle that the terms of public tender notice are not generally open to judicial scrutiny and interference unless found to be per se arbitrary is well known. It is straight law that judicial review would apply to the exercise of contractual powers by government to limited extent of preventing arbitrariness or favoritism. Of course, what constitutes an arbitrary action is ultimately to be answered in facts and substance of the case. I have already set out the factual backdrop of these appeals here and above. It appears to us that assertion that an open tender would render the allotment process cumbersome and time consuming, or the claim that permitting bidders beyond the designated 10 would result in installation of inferior quality of bids is seemingly conjectural and mere presumption based on surmises. Admittedly, all 10 companies flagged by GMC as eligible in the NIT or multinational corporations are now all based out of India. This fact clearly indicates that GMC ostensibly believes that companies' status as global entity ipso facto confers on it requisite repute and expertise necessary to undertake the specified works. In our considered opinion, it is wholly untenable to argue that Indian manufacturers such as the present appellant are inherently incapable of competing with international products, or that any service rendered by them would be of an inferior nature. We, in no uncertain terms, disapprove of such presumptive practices, save and except in a case where the competent authority, after following an objective analysis by an expert team, arrives at a well-reasoned, non-discriminatory and scientifically supported conclusion. No such argument or supporting material was submitted to the GMC to the High Court or before us. We further believe that there are several other remedial measures.
Save and except in a case where the competent authority, after following an objective analysis by an expert team, arrives at a well-reasoned, non-discriminatory and scientifically supported conclusion. No argument in support of that have been submitted by the GMC before the High Court or before us.
Please, my lord.
You have to obtain instruction, let us obtain it as
Let's,
whether they have or not.
Please, I'm quite
Let
alive.
us have it on Tuesday or when is the last date?
26th, my lords, we made a representation on 14th. Or at that point of time, my lords, we had
26th is the last date on 25th.
25th is the holiday.
We, let
25th
us have it on 25th,
25th is the holiday.
the 25th is a holiday.
26th. Okay, 26th is the last date, no?
They-
26th.
Last date for submission of tender, it can be extended in that case, Lordship.
Okay,
that is-
they say, I will record it, it can be extended.
Plus, may I just make a small, if your lordship permits? Plus, this matter traveled to the Supreme Court. Because I was
No, you see.
the other
Supreme
18 high
Court-
courts which have taken a similar view.
Very well. But you see-
I will convince your lordships
Mr. Counsel-
independently. also.
Mr. Counsel, listen. The Supreme Court had passed the judgment out there on those facts. We are concerned out here, the Supreme Court gives an exception. Whether the exceptions will apply or not is the order which I am going to pass now. Now let them produce it on 20.
Whether that any process has been carried out.
Absolutely.
No,
If it is not, then you have a
Certain,
clear
and
way.
my specific averments are there to the extent that they have not followed any process.
So
This
let
is
us.
cherry
let-
picking, my lords.
We have to give them a chance. Let's give a chance. We believe in giving opportunities. We'll see.
Your lordship, if they are extending it, your lordship may have it next week, my lords. We can also have a look at what response they are filing, my lords. If they are extending it by 26, it will, my lords.
I'm not asking them to file response. I'm only asking them about whether there has been any scientific evaluation carried out.
Please,
If they have done so, then it would be on a different line. We will consider as to whether and produce that.
certainly.
If that is done, then we will consider as to whether to extend it or not, that we'll consider on 26th. But as of now, let us give him an opportunity as to whether he meets or not. Otherwise, the judgment passed by the Supreme Court is otherwise takes care of your situation. We'll look into that. Don't worry. Okay. You are appearing for?
Or both the respondents also.
Action notice, making it returnable on 26/8/2025.
Lord.
At 2 p.m.
Lots. Deeply obliged, Lordship.
Wait, not done. Mr. Who is your junior? Mr. So-and-so.
As to the Lordship.
Accepts notice on behalf of the respondent number 1 and 2. First of extra copy of the petition be served upon him during the course of the day. The learned counsel appearing, it is the case of the petitioner herein is aggrieved by the tender by the qualifying criteria incorporated in the notice inviting tender dated 24/6/2025, whereby only certain brands were held to be eligible to participate. Full stop. The petitioner, upon coming to learn about the said notice inviting tender, had submitted a representation on when?
It was 14th of August, my lords.
Where is it?
It was page number 169, my lords.
On 14th of August 2025.
It has been rejected at page 172. They have rejected that, my lords.
Requesting that the petitioner's brand also should be taken into consideration, should also be brought within the ambit of the qualifying ambit of the brands which are eligible to participate. The same representation have been rejected by the communication dated 18/8/2025, informing the petitioner inter alia that the technical committee, expert committee of the institute had approved the brands of the lifts to be installed in the institute. Mr. Is this reported? Mr. Counsel,
Please, my lords.
is this judgment reported?
It's all,
Nowadays, you get every judgment of the Supreme Court orders reported. What is this? It should be reported somewhere. What is the civil appeal number?
please, my lord, the lordship would have it. Civil appeal number 13716.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner has drawn the attention of this court to a order passed by the Supreme Court in special leave to appeal, bracket C, number 13716-13717/2020, wherein a similar issue arose in view of an incorporation of a similar clause by the Gwalior Municipal Corporation, thereby only limiting the eligibility of the participating brands to certain international brands.
Please, my lord.
The learned counsel for the petitioner further submitted that the Supreme Court had made categorical observations in the order dated 4/2/2025, observing that it was wholly untenable that such conditions can be incorporated unless and until the competent authority, after following an objective analysis by an expert team, arrives at a well-reasoned, non-discriminatory, and scientifically supported conclusion that the other brands, and more particularly the Indian brands, are not in a position to fulfill the requirements of the tender. This board, also having perused the order passed by the Supreme Court dated 4/2/2025, finds it relevant to incorporate, to reproduce the paragraphs 8 to 12 of the said order hereunder. From a perusal of the above judgment, it therefore prima facie appears that the Honorable Supreme Court had frowned upon the Gwalior Municipal Corporation for excluding the Indian brands and thereby only including the international brands. The Supreme Court also observed that the Gwalior Municipal Corporation ought to have acted in a more transparent manner, keeping the observations which were made by the also observed that the Gwalior Municipal Corporation ought to have acted in a more transparent manner. In that view of the matter, this court directs the respondents hearing to apprise this court on the next returnable date as to whether there has been any scientifically supported conclusions arrived at by a competent authority by following an objective analysis by an expert team that the brands mentioned in the bid document can only be considered, leaving aside brands like the petitioner.
Let's, I would like to let's point out, your lordship would kindly see page 25. Let's at 2 p.m. On the 26th is the last.
10:30 a.m.
I want to be it at 2 p.m. I'm saying that your lordship may allow me to participate and my bid now may not be.
I don't have that doing at a line at a lake.
It's 10:30.
Mr. Article, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, however, submitted that 26/8/2025 is the last day for submission of the bids. First, Mr. R.P. Kakoti, the learned senior counsel. No,
Lordship, have it at 2 p.m. I'm not having any objection.
The
to
last date. Taking into account the above, taking into account the observations made by the Supreme Court in the case of Omega Elevators Supra, this court directs the respondent numbers 1 and 2 to extend the bid submission date to any date on or after 30th of August 2025.
Lordship is having it on at 2 p.m. then.
Otherwise, it's.
I'm grateful.
Oblige.
Reason. Non-specific, my lord. What are the ground for the cancellation of my lord? So I rely on the decision of this apex court, my lord. Now, if they want to extend, they can extend my lord. Lordship, sorry, it too much doesn't. This is the.
Oh, it was.
My lord has also regarding this judgment in other cases. Huh?
Which paragraph?
My lord, the paragraph, it starts from paragraph, my lord, 12. Paragraph 12, how it was cancelled, my lord. Lordship will find paragraph 12. However, on 17/2000, respondent issued another notice to the appellant stating that tender for work of maintenance has been cancelled on account of technical fault in the tender. So, my lord, their action was put to challenge before, letter was put to challenge before the Honorable Calcutta High Court. Single bench rejected, dismissed the writ petition.
What did the Supreme Court hold?
The Supreme Court hold, Lordship will find, my lord, this is the Supreme Court discussed about the arbitrariness vis-a-vis, my lord, the action. They said it is non-specific. In my case, it is also non-specific. They have evaluated the tender, my lord. They have verified the every document. Perhaps, they have my concluded, they have verified the technical bids. Then the committee has come to a conclusion that my bid is responsive. My technical bid was evaluated. Now they are saying that this is mistake you have made. It what misrepresentation I have done? There is nothing on the record. My lord, paragraph, then lordship may look into the paragraph 33 also. That is the submission of the, my lord, the appellant hearing. Before the Supreme Court, my lord. Please put on paragraph 33.
And Mr. Gogoi, have you intimated the petition?
No, that part probably not been done. But that we can, my lordship will indicate, my lord, we will give that particular, my lord, cancellation order, whatever justification is there, we will intimate it in the meantime.
Now, if you have not, how will you challenge that?
Yes.
No, that's why within, my lord, this period, by say, my lord, Tuesday, we will, my lord, provide that part. So,
Then how will you challenge it? Means if you, then the tender proceedings has to be stayed. We have not intimated him. Because his right to challenge the cancellation is there.
of course, that is
He
there.
cannot challenge on the basis of the contents in the averment.
Yes.
And when that too, when there is a direction being passed.
Yes.
So this tender has to be stalled. Although I don't like to stall tenders, but this has to be stalled.
My lord, in that case, my lord, by Tuesday, if we can communicate it to the petitioner, we can even mail it, my lord, it's not that, my lord.
The petitioner here says that without any reasons.
My lord, that reasons we will give.
So therefore, this tender which have been issued
My lord,
would not have been issued without intimating him first.
not so. My lord, in that case, my lord, may I have the instruction, just my lord, after 10 minutes, we will try to, my lord, intimate it today evening itself, at least you will.
How
get
is
the chance.
telling it today?
No, if you intimate him today also, but how will you give him the right? He also has a right to challenge.
Yes.
That is also a right.
My
A
lord.
right to approach the court and seek judicial redressal
Yes.
is also a fundamental right.
Yes.
If not a constitutional right, it's a constitutional right. So how will he challenge it?
My lord,
I would have understood. You filed the affidavit, the order was passed in the month of May.
my lord, my lord.
Then on why on earth didn't you issue a notice to him telling that we are cancelling it for these reasons? Now you have a right, he has a right. He has come before this court stating, you look here, without assigning any reasons, he has cancelled it. And even the order passed by the court by which there was a direction to intimate him has also not been done.
My lord.
Now, how do I challenge it or do anything? So therefore, there is no reasons for which the cancellation is bad. So therefore, now if you see, although Mr. Ghosh have not been pointing out, in paragraph 93 of the judgment,
My lord, my lord.
he has got the judgments immediately, so therefore he has not been able to.
The word may cancel, the word clearly indicate that a respondent at that stage by no means was the opinion that tender was required to be cancelled.
In fact, my lord, after perusing the record in this particular case, Honorable Supreme Court held that, my lord, it was wrong. That ground was wrong. In fact, my lord, there was some political interference.
Now, when
Not-
the court had directed you.
Yes, that will have to,
grounds, without providing the grounds, if you go ahead
my lord, my lord.
and you are having it as tomorrow is the last day or today is the last
My
day,
lord.
how do you take care of a situation like that?
No, my lord, if that extension is made and if we can serve the, my lord, particular cancellation order with any ground, my lord, by today itself, he can, my lord, participate also. He can, my lord, challenge also, my lord, up to him.
And succeed, then what will be the effect?
You extend it by 15 days
Lordship,
and give him by Monday.
or Tuesday, Monday.
Then he would have a reasonable time in challenging that,
Lordship.
which will be subject
In the
to
challenge.
the court
Then what
considers
is the-
as well in.
10 days, my lord.
Asking him to extend it by
10 days,
15
my lord. Let it be 10 days, man. Because he will have enough time, man. We will
No,
try to serve it
5
today.
days is gone. You are going to give it to him. I'm asking him from today 15 days. Meaning that by 5 days is always gone. Saturday, Sunday, Monday, Tuesday, Wednesday. Saturday, Sunday, Monday, you are not giving, you are going on Tuesday, 4 days is already gone. He will have, then I'm asking you to have the tender rescheduled on sometime in the month of, the first of September, this 15 days would be one, 2 weeks, by 8, on or after 8th of September. The 15 days, 4 days is here, gone.
My lord.
But you have to give an undertaking that you are going to serve him by 26th.
Lordship,
Then only he will get a right.
my lord.
Well, this matter then will remain pending, my lord, this
Pending.
Yes, my lord.
It shall be pending,
Yes.
pending, because his right is there, because
Yes.
otherwise, if I dispose it of, it would become difficult.
Yes.
My lord.
Yes. We can do it.
Because tomorrow, if I say, but if you don't give, he cannot again challenge it.
Yes.
If I keep dispose it of.
My lord.
Problem is, Mr. Gogoi, the main problem which I see out here is, otherwise, the order passed by this court is being not taken.
I understand.
So you have to extend it by on or after 8th of September. In the meantime, Mr. Ghosh can challenge.
Yes, well, let it be 8th of September. Yes, 8th of September.
Yes, what do you say? What is your able junior asking you?
No, my, I agree with the lordship, my lord.
Let it be
Lordship,
5th, my lord. Let it
let
be
him
5th.
submit a
Till
the,
5th, my lord. Because he will get enough time, my lord, because
How fifth?
5th of September.
You are going to give it beyond 26th.
Yes, my lord, at least
Then-
he can file it and move
Why
it.
not by 8th? Monday only.
My lord. Not so.
and my lord, this NIT, my lord, will be subject to outcome of this petition, this may be, my lord. This, because if the challenge is not arbitrary, my lord, in that case, then I have to file another writ petition, my lord.
You have to file.
Yes, my lord.
You have to. They cannot be subject to outcome.
Yes,
This is only for the purpose of extending.
yes,
I'm extending it. He is going to give you by 26th, 25th, 26th, he's going to give you.
lordship.
Thereafter, what challenge happens is your thing.
Yes,
Whether
ma'am.
you get
Yes,
an
yes.
order from this court or not, it's
Yes,
a different thing.
Yes.
But by 8th, the matter finishes here.
No, lordship may dispose it off with granting
No,
liberty
that-
to the petitioner to challenge, my lord, this particular tender process. If he finds that, my lord,
I can't because you see, it's like once bitten, twice shy.
Yeah.
Because the court have directed you to supply and you have failed.
lordship.
And if I dispose it of, again I'm putting at the mercy of yours and you won't give. You may give it on the 8th morning and say that finish.
Yes.
As Mr. Ghosh is very.
Then lordship will post this matter on 8th.
Yeah.
In the meantime,
Issue notice making it returnable on 8th of
Lordship.
September 2025. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD department, accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the writ petition be served upon him during the course of the day. The facts which led to the filing of the instant petition, as can be discerned from the pleadings contained in the writ petition, are that a detailed notice inviting tender dated 5/9/2024 was issued for 156 numbers of packages for improvement and construction of roads in Tea Gardens under RIDF-XXX of NABARD for the year 2024-25 from eligible and approved and eligible categories of contractors registered under the PWRD Assam. The petitioner participated in the said tender process and submitted his bid on 7/10/2024 in respect of the work, namely, inverted comma, construction of road from Jalalpur Rimbai, RYMBAI Road to Kalansera BSF camp via Natanpur Garden LT School at Kalansera Tea State under the RIDF-XXX of NABARD for the year 2024-25. The petitioner's bid was duly accepted. And a letter of acceptance was issued on 7/3/2025. The petitioner also furnished the performance guarantee of rupees 1,80,000 in the form of TDR/FDR by term deposit advice dated 10/3/2025. Thereupon, a communication was issued dated 11/3/2025 by the Executive Engineer PWD Roads Development Branch through email requesting the state bank authority to verify and confirm the account number 61440303003089 dated 10/3/2025 amounting to rupees 1,80,000. The said were also duly confirmed by the competent authority. The petitioner thereupon, on the basis of the letter of acceptance, proceeded to mobilize its resources and also claimed that he had invested a huge amount of rupees 10 lakhs. What is this, 10 or 15?
15 million. Yeah? 15 million.
At page number 7?
15 million. Look, it's only, there is some
10 lakhs.
What, 10 lakhs.
10 lakhs.
I'm sorry, Lord.
But in absence of the formal work order, the petitioner was not in a position for executing the said work, even though the period of completion of the work in the DNIT dated 5/9/2024 was 9 months.
Yes.
It is under such circumstances the petitioner had approached this court, filing a writ petition which has been registered and numbered as WPC number 2963/2025. Full stop.
My lord,
On 13/6/2025, the counsel, the learned additional advocate general, who represents the respondents herein also, submitted a parawise comments dated 5/6/2025, wherein it was mentioned that the respondent authorities have decided not to issue the final work order on the ground after assessing all the relevant factors and in the interest of project integrity and timely execution. It was further mentioned that in order to avoid project delays, cost escalation, and to prevent further loss to the public exchequer, the department was actively considering engaging another eligible bidder from amongst the originally qualified tender participants in accordance with the tender terms and procurement norms. On the basis of the said parawise comments which were placed before this court, before the learned coordinate bench of this court. The learned coordinate bench disposed of the said writ petition by the order dated 13/6/2025. Observing that as the respondents have taken a decision not to issue a work order to the petitioner, the formal communication of the decision made by the department should be communicated to the petitioner within a period of 1 week from the date of receipt of the certified copy. Paragraph number 7 of the said order dated 13/6/2025 being relevant is reproduced herein under. Did you produce the certified?
Yes, yes, my lord. I mean, next page 31.
What is this?
32, my lord. Page 32.
32 is this signed and signature. That is a type copy. 32 is the.
The petitioner duly submitted the said communication. Says the petitioner submitted the certified copy of the order on 17/6/2025. However, the respondent authorities admittedly did not intimate the petitioner the order. The intimate via formal communication its decision not to grant the final work order to the petitioner. It is further seen that on 1/8/2025, a press notice inviting tender was issued for 2 numbers of packages for construction of improvement of roads under RIDF Roman 29 of NABARD for the year 2024-25 in the Kachar and Sonitpur district, amounting to rupees 199.69 lakhs. In the detailed notice inviting tender, the work which was earlier allotted to the petitioner by the letter of acceptance dated 7/3/2025 and which was the subject matter of WPC number 2963/2025 was included at serial number 1. The petitioner, on coming to learn from the said detailed notice inviting tender, it is seen that the publishing date is on 4/8/2025 and the last date of submission is today, that is on 22/8/2025 up to 2 p.m. The technical bids are to be opened on today on 22/8/2025 at 2:30 p.m. Being agreed by such action on the part of the respondent authorities in cancellation of the tender, that too without assigning any reason, and further for non-compliance to the order dated 13/6/2025, passed in WPC number so-and-so, the petitioner has approached this court. This court inquired with Mr. B. Gogoi, the learned additional Advocate General, as to whether the order dated 13/6/2025 in respect of passed in so-and-so was duly complied with by providing the petitioner the decision as directed to be provided within a period of 1 week from the date the certified copy was served. The learned counsel with all fairness, learned additional Advocate General with all fairness submitted that The said decision have, however, not been provided. Full stop. This court, having taken into account the pleadings as well as the materials on record, is of the opinion that when a decision is taken to cancel a tender, the said decision has to be within the confines of Article 14 of the Constitution. An unreasonable exercise to cancel the tender would can be interfered with in exercise of the powers of judicial review. First, in the instant case, it is seen that if the decision so taken not to grant the work order to the petitioner was communicated to the petitioner could have very well assailed the said decision. A right to approach the court seeking redressal of a grievance is a constitutional right. This right have been the materials and records show that this right petitioner have been apparently violated. This court further inquired with the learned additional advocate general to within what time the decision. Mr. B. Gogoi, the learned additional advocate general, submitted that the decision not to grant the final work order to the petitioner, which is in respect to the work with petitioner, as directed by the learned court bench of this court dated 13/6/2025 in WPC number so and so, can be communicated to the petitioner by 26th of June, August.
Yes.
26th or 25th? 26th.
26.
By 26th of August 2025. He, however, submits that taking into account that the petitioner is duly represented by his counsel, he would serve the said copy of the decision to Mr. B.J. Ghosh. Huh?
Yes, yes.
No. Because otherwise, if he doesn't accept, then the
Yes, yes.
to Mr. B.J. Ghosh
Right.
on 26/8/2025. In that view of the matter, this court, therefore, is of the opinion that certain interim directions are required to be passed in the instant proceedings. The interim directions, which accordingly, this court therefore directs Mr. B. Gogoi, the learned additional advocate general, to serve a copy of the decision in respect to not granting the work order to the petitioner, which is the order directed to be passed, provided to the petitioner by the order dated 13/6/2025, B. Serve upon Mr. B.J. Ghosh, the learned counsel appearing on behalf of the petitioner. Service upon Mr. B.J. Ghosh, the said decision would be deemed to be a service upon the petitioner. Next. This court further taking into account that there is a right of the petitioner to seek redressal against the said decision. This directs the respondent authorities to issue a corrigendum to extend the period of submission of the bids on or after 8th of September 2025. The petitioner would be at liberty in the meantime to challenge the said decision. Footstop. Next. This court, before parting, this court finds it very pertinent to clarify that this court have not decided on the decision taken by the respondent authorities not to allot the work order to the petitioner, which shall be subject to any proceedings so filed by the petitioner.
Yes, sir.
On 8th, the matter will come out or 5th. Anything.
I've given it 8th. Issue notice returnable on 8th. And the respondents are given the liberty to file, is directed, shall bring on record their instructions by way of affidavit on or before the next date. This court further grants the liberty to the petitioner to submit its bid in pursuance to the present tender which is being challenged, and such participation shall not prejudice the petitioner in the present proceedings.
Item 16.
What is this?
My lord, is short is the synopsis, so short is the fact in the case, my lord. What happened here in Lumley, my lord, there is a old dilapidated Shiva Mandir, my lord. For development of that, every year Puja was and Diwali was celebrated in that mandir.
What you want to have? This, what you call, Sandimunda?
No, not Sandimunda.
What?
Prize money.
Some playful events and a symbolic lucky draw.
Lucky draw. So, sort of, my lord, we will purchase some TV, something. And lucky draw means, my lord.
What, Mr. Sharma, you are asking all the government advocates have fled away.
They are afraid of Shiva.
They have all fled away. Yes, ma'am, sued us.
Central government, my lord.
What central government? State government.
Yeah, but we have cost list also doesn't show, my lord.
This is Sansita
Yes.
Chetri Day.
Yes, my lord.
All our state government,
We don't have-
secretary edition.
Is in the cost list, it is shown as, my lord, so we don't have record in the. You find to the other.
It is sort of matter.
That's why, my lord.
I will appear if there is no government advocate, no difficult. I will love to appear against him.
Not in my favor. He always appears in my favor.
Deputy. So he may not have given the, anyway, government of Assam is here, Lordship, I am appearing.
I would like to seek your kind approval for conducting traditional playful events, including a lucky draw, as per part of the upcoming religious ceremony for the establishment of Lord Shiva Mandir at Brickfield Colony. These events hold cultural and devotional significance in our community and have long been a part of such spiritual gathering. Mr. Sharma, how on earth do you say that you have experience in respect to this, or you have been holding, when it is a case of establishment of a Lord Shiva temple?
They have to collect money, otherwise they have to collect money.
No, understood, but you say that these events hold sway and have been a long part of our spiritual gathering. But how is it possible that for establishment of means, are you experienced in many other places of Lord Shiva gathering, you to hold all this time?
There they celebrate it, my lord, but this time,
This is for the purpose of establishment of the Lord Shiva temple.
yes, they want to collect some money.
Lord Shiva temple is being established. Only one.
This one.
Permission cannot be granted for any lottery or lucky draw. Yes.
There is the order.
There's a standing bar, Lordship. If Lordship recollects last year, during the Diwali also, this honorable court came up very heavily by taking recourse to the Lottery Act and all. So any form of this kind of activities are totally barred from the division bench. And we tried our best because some of the.
How on earth can this court issue a writ for allowing you to have lucky draw?
No, my lord, local people do it.
You
because
do?
we have to agree.
Who has asked you not to
But
do?
we want to
Do it.
go, we want to go formally, my lord, that's why we applied, otherwise,
Sharma, you need the stamp and authority of the court.
no. That's why we applied. Formally, we wanted to.
What did you like? A dismissal?
No, not dismissal.
Royal? No, I'm not going to give direction for doing all these things. No. And they have not allowed you to have other playful events.
Yes,
They have only asked you permission cannot be granted for any lottery or lucky draw.
yes.
That's it. You can go ahead with others. Have the shooting with that particular box out there. Have those.
Yes, my lord,
But it should not
that may
involve
be
any
verified.
monetary consideration.
Yes, my lord. Following the division judgment, my lord, this is.
That nobody has stopped you also. You see, everything is permissible. Permission cannot be granted for any lottery. You can do other things. Have it.
With their observation, your last minute is up. Except the lottery or lucky draw, they can do other.
It is already there. Why should I say?
My lord, this may mean otherwise also. We may even be prevented.
I can only record that Mr. R.P. Sharma, the learned senior counsel on instructions have submitted, that taking into account that the petitioner is being allowed to have, what do you call, conduct traditional
Cultural and devotional
events, except lucky draw
or lottery.
or lottery,
Yes.
he would not like to press the requisition. That's it. That is the most face-saving order you will get.
Hoga. Chlega.
Lucky draw has become unlucky now.
Huh? No.
No, he is creating all the problems already. Assam, intra-Assam, he is creating entire problem.
He got all the best benefits for Gorkha community. He's the leader of Gorkha now. And he should be very thankful to us. Isn't it? Yes, he's admitting. That may be recorded, Lord.
I don't know. Actually speaking, my lord, it is the High Court which has given the everything we wanted, the Gorkha community, and on that basis, government has passed orders in our favor everywhere.
Okay, Mr. R.P. Sharma, Mr. R.P. Sharma, the learned senior counsel assisted by so submits upon
He does.
instructions that as the petitioner have not been as the petitioner's request to conduct traditional playful events other than have traditional playful events have not been rejected other than lottery and lucky draw program, he would not like to press the petition. Accordingly, the writ petition stands closed on withdrawal.
In fact, there is a standing order of the division bench. If any
That-
deputy
that
commissioner
right.
allows, he will be indulging contempt of court. There is a standing order
Well,
last
that
year,
may be
just
noted.
before the Durga
That
Puja.
division order may be noted, so that I can satisfy to that.
I reckon Mr. D. Saikya, the learned advocate general, also submits that the question of granting permission for any lottery or lucky draw cannot be does not arise, taking into account that there are standing orders passed by the division bench of this court that no such permission should be granted.
Yes.
Yes.
তোমাদের then
এইটো এটা কাম কৰিব
then there is no withdrawal matter.
First, Mr. D. Seke, advocate general লিখি দিব, then submit. And Mr. R.P. Sharma on instructions submits that he
But then matter it may be disposed of only. That observation, no need of withdrawal. because-
Dispose.
Yes. Without noting down that I have withdrawn it, the lordship will dispose on the basis of.
You want the disposal?
Yes. On the basis of the division bench order matter.
Heard Mr. R.P. Sharma, the learned senior counsel, assisted by so-and-so,
Jesus.
and then. This one. Taking into account that Mr. D. Seke, the advocate general, taking into account the issue involved, had inquired with Mr. D. Seke, the learned advocate general, who was present in the court, as to whether any directions can be issued for consideration of the representation submitted by the petitioner to the district commissioner Hosai. The learned advocate general submitted that there are various orders passed by the learned division bench of this court, wherein specific directions have been issued that there cannot be any permission granted for any lottery or lucky draw program, including any programs which have betting activities.
Betting activities and including lordship in any form.
Betting activities in any form. So taking into account the above, this court dismisses the instant petition.
Deeply obliged.
Item 17.
Will be there. Close the disposal.
No, that was earlier I was withdrawing it. Therefore, I'm saying.
Anyway.
So the considering, therefore, in view of the above, the question of issuance of a direction for consideration also does not arise, for which the petition stands dismissed. Yes, Mr. Hawk.
Very curious lordship. My lord, here, my lord, the director of handling textile, my lord, has floated tender, my lord, on 25/7/2023, my lord. My lord, petitioner participated, my lord, in the tender process, my lord, and subsequently, my lord, although, my lord, the bid, opening of technical bid was.
Technical bid rejected.
No, my lord, accepted, my lord.
Now what has happened?
Petitioner was declared as L1, my lord. He was, my lord, issued the LOA, my lord, with requiring.
Payment not given.
No, my lord. Requiring, my lord, the petitioner to submit additional performance security, my lord. I am on the, not on that part, my lord. I am on the part that, my lord, that there is a delay, my lord, in.
Of HTCA dorsal in terms with the notice inviting tender dated so and so. Yes, to dispose of the representation of so and so. Okay. This is only notice to be issued,
No,
nothing.
my lord will come to page 150. And my lord, he doesn't have any case, my lord. Why he is before this honorable court, I don't know. Page 150 of the writ petition, my lord.
You must have come out here taking into account that in your department also insists on MLA's sum. What is that? Somebody is moving at 2 o'clock matter. You must, yes, what is this?
My lord, he was before this honorable court and he got an order, my lord. This is the order, my lord, 150. And there was a specific direction, my lord, to the respondent authority in page number 155, para 13.
Are directed to accept the additional performance and rate of so and so, besides the normal or NEA and the impugn letter issued by ER to the extent that it has asked for additional so and so in here basis. Then,
My lord has done this para 13, my lord, page 155, the direction. My lord, we communicated 3 letters to him. Please come and deposit. The last page, my lord, page 160.
in reply.
My lord, now he is shying away to, my lord, follow the honorable court's order. Now in a disguise, he has come before this court, my lord, circumventing this coordinate bench order, my lord, and he's here in the form of an appeal. Whereas he has got an order, my lord.
No, Mr.
My lord,
Can
misleading
you
submission has
bring
been made.
before this court these letters? Your letter dated 11/7 with the subject seeking reply and request for award. With reference to the cited above, it is to make you aware that you are originally selected here below and then the estimated here so and so. In this conversation, it may be stated here that the undersigned cannot consider your request for deviation from the rate quoted by you against the estimated rate of the project. Moreover, as per the order, you were requested to deposit 5% so and so for the work of reconstruction of so and so, but till date you have not submitted the same. In view of the way, you are once again requested to respond. Oh, the reason I know why he has approached. By this, what he is asking that otherwise you are going to terminate and then take whatever maybe some blacklisting you do.
No, that part we are not going, my lord. Means, my lord, there is a specific direction by this honorable court in para 13 in page number 155. In view of the reasons stated above, the state respondents are directed to accept the additional performance security at a rate of 26.16 minus 5% is 21% as per the office order dated 15/11. Besides the normal performance security being submitted by the petitioner at 5%. Consequently, the impugned letter of acceptance dated 13/6/24 and the impugned letter dated 27/24 issued by Director Handloom and Textile Assam to be to the extent that it has asked the additional performance.
No, my lord, I am totally not on that, my lord. I am only that, my lord, that, my lord, the NIT was.
First, Mr. Hawk, have you complied with paragraph 14?
No, my lord. Because I had submitted the application, my lord, what happened, my
No,
lord?
no,
I
no,
can't
I'm
come
asking
to-
you, have you complied with paragraph 14?
No, my lord, not yet, my
Let
lord.
them finish.
No, my lord. No, my lord, what I am, this present petition, my lord, is on different ground, my lord. Because I am, my lord.
You
that-
want this court that they should issue you the work order.
My lord, that will be if I submit the additional performance security, my lord. Then I am accepting their terms, my lord. Now, what is my grievance, my lord? Kindly come to page 159, my lord.
Yes.
Kindly come to 159, my lord.
Ah.
Here, my simple grievance, my lord. Petitioner, my lord, that work was floated in the year 2023, my lord.
My lord, he had a stay, my lord. My lord, there was a stay order on this from 23 to 25.
Now, what do you want? What is your relief you are seeking
My
for?
lord, I am seeking the award, my lord. Maybe on the estimated price, my lord.
Not be issued to dispose of the original years, then we issued to award the work at so and so as per the estimated rate. What is now paragraph page 14? A rate in the nature of mandamus shall not be issued to the director to award the work of so and so at dorsal in terms of the NIT dated so and so.
Yes, my lord.
What is that there?
My lord, that pay, my lord, the original, my lord, estimated price, my lord, that was floated in the NIT, my lord. Now I am seeking, my lord, that work which I am going to perform, my lord, that award may be given at that rate, my lord, estimated rate. Because in this meantime, my lord, 3 years of time, my lord,
So you
there is
quoted-
inflation, my lord, price.
You quoted
Royalty.
rate less.
29 below.
For which you had to quote, given additional performance security.
That is different.
No, no,
Yes.
yes, that is very relevant.
My-
You have to give a additional performance
My-
security. Now your case is
My lord,
that as by the time you approached this court
my lord,
and there was a delay,
my lord,
and therefore now you are not in a position to do that work
my lord,
at that rate you have quoted.
my lord.
So now you say that kindly give me the same tender at the rate which have been quoted,
My lord,
which was the tender value.
my lord.
This is your case.
Yes, my lord.
So what should I do? Dismiss? That is one. Which one do you want?
My lord, they admittedly, my lord.
No,
they
no,
are-
otherwise what is going to happen? That is why I asked you.
Yes.
Have you not gone for blacklisting? I will not go for security, the revocation, invocation, the security report. The reason is, what he is asking out here is, he's taking the plea of the doctrine of frustration. That because of the delay in pendency of the writ petition which he filed here,
Yes.
he is not in a position to do this, and therefore you kindly give it. This is what, therefore I am asking you, is it your case that you are going to take the security deposit? Because if it's a case of termination, if he does not, it is a case of termination. The next consequential action of termination is you are going to revoke the bank guarantee. For 2 years, nothing has happened. Have you done that? This is a prelude to that.
My lord, 2 years, they are the stay. So it isn't.
Stay,
my
who
lord.
got it?
He got it.
That is what I am saying.
Yes, my lord.
When he gets a stay, it is his responsibility to do the work at that rate. Now, how can he come in? You are not seeing the foreseeable feature of what Mr. Hawk is trying to do.
Exactly, my lord.
The way you should notice, at least.
My lord.
Nothing more than.
My lord.
But it shall not. But I think you should take action. You go. Notice a dismissal. Dismissal.
My lord,
I can't allow this.
Yes.
this can't be, my lord, because he is the one who has quoted 29% below initially. His part, my lord. He came into, now, my lord, the court has given him what he wanted.
No. This is a case of dismissal.
My lord, here also, my lord.
There are two ways out. Either you take an adjournment today or take a dismissal. I can't issue a notice in this type of matters. My conscience does not.
Yes, my lord.
Because the notice,
appreciate
if I
the
issue
conscience of my
it,
lord.
I know what is going to be the next consequence. This will go for another 2-3 years.
Yes, my lord.
And
Ultimately,
with
it will be
2-3 years, again you are going to repeat. And thereby that work is getting stopped.
Exactly, my lord.
Then
We have given him 3 reminders that please come and
yes.
comply High Court's order.
Which one do you want? Adjournment or dismissal? Like I asked Mr. R.P. Sharma, withdrawal or dismissal? He said for first withdrawal, then I withdrew, then again I dismissed it because he won. Now what do you want? No withdrawal. Withdrawal doesn't matter. This is a case of either dismissal or adjournment. Next thing, you have a good judge. That is also another.
I am not on that, my lord. I am totally not.
His case is, my lord, he can't.
I
He
have
has taken
understood,
a
I have understood more than what you do.
my lord.
There's nothing to be.
Yes,
shy of.
of course, my lord.
You have to think about your client.
My lord, only that part.
Yes, what one?
Next Tuesday, my lord.
Huh?
Next Tuesday or Wednesday.
At the request of the learned council, the matter stands adjourned to be listed on 29th.
My lord. Obliged.
Item 19.
What is this? Non-payment?
No, my lord.
What is that?
The petitioner has.
IMFL.
IMFL.
You are there, IMFL. What has happened?
But he has initially applied for
Shift
shift
of demand,
the
the event the line. In here compared. The shift in application and after implement all the direct in the petitioner to shift. So you have all the problem to yourself.
Yes, sir. That is the thing. my lord.
Initially, show cause notice was issued to the petitioner lordship that initially he has shifted his shop without any permission lodge. That is why he replied to the show cause notice and he written to the officers that he will shift automatically lordship. Now, when shifting order was passed, now he has challenged his order lodge.
Because
That
my
cannot be
lord,
lodged.
one thing, my lord, the license was for IMF on shop, and on shop customers are not there. Almost my business was, my lord.
You shifted earlier without
Permission.
without
Yes, yes.
permission.
Yes, yes.
Now, when you have asked out here that why you are shifted without permission, then you say that I want this permission,
Yes,
I want the permission. They give you the permission and thereafter, now you say that kindly don't give me the permission. What
Yes.
type of matter is this?
Well, my lord, what happened, by this time policy of the government has come that they are going to, my lord, off to on conversion has come. That is why, my lord, he has decided to stay.
You know, once it has been shifted, then you have to again file an application for another shifting. Now that is again another problem. This type of practice cannot happen because you have already shifted.
Lordship.
Not
Yes.
shifted,
No,
yes,
no,
sir.
you have shifted because of that they issued the show cause notice.
Page 35. Yes, Lordship. Yes.
Yeah.
Then in the reply, my lord, he has stated, my lord,
No, page.
His replies
he reply, he has stated, my lord, he needs 90 days time, my lord.
For shifting.
And shift.
To circle officer submission of the where is this show cause notice?
35.
Focus on
Page
35, my lord, 35.
35.
35.
35.
He has given the reply, my lord, in 36.
So it has been revealed from joint verification of the forest and excise that your license premises is not located at the original government site and the rented house of so and so. And rather it is located at a different place at Jacobpur Forest Village under so and so as per the report of DFO filer a few kilometers away from the original. Moreover, after verification, it is found that no previous sanction was accorded from the government for shifting. Then you say that my MF is running in the rented premises of so and so covered by so and so. But it has been mentioned that the land allotted under so and so in favor of so and so as per IMA. Therefore, sir, I applied for IMFL on license that the plot of land and according to the issue. As per the and subsequently your good office my license, issued my license and accordingly I am running my shop and regularly depositing from Iman. So as per the you stating that my shop is not running in the original place and as per the I had submitted a shifting proposal of my Iman copy enclosed. Copy enclosed, where is the copy enclosed?
Not that, not enclosed.
Huh?
That is the
Nice one.
In the petition filed by so and so. And considering his prayer is hereby directed to seek or relocate his. The license premises from the present location, that is so and so. Either. So you have been asked to move from Jacobpur Forest Village.
yes.
Huh? Then you file another writ petition.
No,
No.
there is another Lordship.
What has happened here?
Initially, my lord, his license was stalled due to the complaint of the local people. Thereafter, he approached this honorable court, and this honorable court directed the authorities to pass a speaking order. At the basis of that, my lord, page 21.
Mr. Goswami, I think we'll just issue a notice. Issue notice making it returnable. How long will you like for filing the affidavit? 17th September?
Lordship.
Issue notice returnable on 19th of September. Pustam. Mr. N. Goswami appears on behalf of the respondent numbers 1, 2, 3, and 4. 3 also, na?
Lordship, right?
Because this is excise.
Yes, it's collector.
1, 2, 3, and 4. Pustam. The petitioner's case herein is that the petitioner had applied for shifting from his place of business to a nearby place. This application was submitted by the petitioner was allowed by an order dated 9/6/2025, thereby directing the petitioner to seek the premises within a period of 90 days. The petitioner now had submitted another representation on 9/8/2025 for withdrawal of the permission to shift and the non-consideration of the said application, and for the non-consideration of the said application, the petitioner have approached this court. Full stop. The respondents are directed to bring on record their stand by filing the affidavit on or before 15th of September 2025. Full stop. It is observed that you are asking for interim prayer?
Yes.
Yes. It is observed that in the circumstance, no affidavit is filed on or before 15th of September 2025. This court shall consider passing interim orders on the next date. Lord. Obliged.
20.
Could you give extra copies during the course?
Late result. My lord, in this matter, my lord, the petitioners, my lord, are providing bus services in the Assam University Difu campus, my lord, since 2014. Thereafter, my lord, after expiry of the last contract, my lord, if your lord will come to page number 30, my lord, the respondents, my lord, floated a tender on 5/3/2025, page number 30.
Then?
Thereafter, my lord, we participated in the NIT, my lord. Lordship will kindly see page number 30, my lord. 30. This is the first NIT, my lord, on 5/3/2025.
Yes.
It was for a period of 4 years, my lord. And the minimum average annual turnover was kept at 50 lakhs, my lord. We participated, my lord, but they did not proceed with this NIT, my lord. Thereafter, my lord, they again floated the second NIT. That is at page number 36. On 16/3/2025.
There are also 50 lakhs.
50 lakhs.
Ah.
And we participated, my lord, but this time our bid was rejected on the ground that we did not furnish the annual turnover certificate, which we, my lord, had already furnished, and by representation at page number 41, my lord, we clarified that we had furnished the certificate. Then this NIT also, my lord, they did not go ahead. Then they floated the third NIT, my lord. This is at page number, my lord, 42 on 1/5/2025.
Page?
Page 42.
Then?
Here,
Now
my
they
lord,
have reduced it to 20.
20, yes, 20 lakhs, my lord. Now, my lord, the last date was 21/5/2025, my lord. And 26/5, they rejected our technical, my lord. On the ground that, my lord, we did not furnish documents. Which documents we do not know. So, lordship will kindly see.
Where is that? Information given to you?
Yes.
Good. Where is that information given to you?
Yes, 51, my lord. Page number 51. We submitted a representation on 26/5.
It is not clearly specified which document is as per requirement. Kindly specify clearly that the documents uploaded were not found in
Yes.
order by the LTC as per the requirement of the buyer's added bid.
Yes.
So and so. Okay, this was done on 28th.
28. Thereafter, they proceeded, my lord, open the financial, my lord, and publish the results, my lord. So we still do not know as to what we were lacking, my lord. Our representation was not even considered. Because
So file an RTI, what you are asking this court to do?
But because, my lord, we had.
This is not, first of all, everything has happened, everything is finished.
Yes.
What do you want? If you don't know, first of all, you have approached this court after 3 months.
There is still a delay.
26/5?
Yes.
Almost 3 months.
Yes.
So why should this court deal with this type of matters?
Limited scope, lordship may examine.
Limited scope. Yeah. Why should this court, you should have immediately approached. These are matters which requires to be approached.
We have filed several representations, my lord.
No, you forget about filing. Representation for what? Asking why do you want?
Yes.
What is the reason?
Yes.
Reason, file an RTI. They have to give the reasons. Matter over. What is this type of way? You are filing after a long time. You want the reason, file an RTI. What is this? This court is not here to provide you informations. Yes, what is the reason?
Lordship, I have received the written instruction.
Let me give the reasons and close it. You all should be happy.
Lordship, contract is awarded to respondent number 5.
The committee had disqualified so and so the document uploaded were not found in order by the committee as per the requirement. The said bidder had tried to call contact members of the committee several times to make decision in his favor.
Next is Lordship, next point is more
The
dangerous.
said bidder tried to create political pressure in this issue to make a decision in favor of the bidder. Moreover, during the said vendor's last tenure of providing bus service at Assam so and so, lot of discrepancies have observed in terms of the quality. In view of the above, the committee has decided to reject this. So this is a, what is this? This is the, so we dismiss it on this ground.
Okay, sorry.
We do one thing.
My lord.
The reasons I quote it in the order, so your client will be happy. These are the reasons.
But these are also new to me, my lord. I do not know about this.
So therefore, why should this court spend time on a matter where there are other much important matters pressing demands? Why should we look into these type of matters? You have approached after so many years. 3 months is a long time in these matters. A person has been awarded the contract, then now you want this court.
On the earlier occasions also, we submitted representation. They did not go ahead with the NITs, my lord. In the third, my lord, instance, my lord, he had to be admitted in the AIMS, my lord. He was there for 1 month, my lord. So there has been a delay. And because of that medical reason, my lord, I have annexed the document, my lord. So that is the reason, my lord, for.
You do one thing. I reflect these reasons and close the petition. And giving you liberty to file, challenging it. Well, because these are the reasons you have to challenge these reasons. Let me come back. Look, I think this is the way out. Because without a challenge to these reasons also, you cannot. By way of an affidavit, you cannot challenge it. So you need to file a fresh one. But these are the reasons. Then they will have a right to reply. Yes, Chaudhary Brothers. The petitioner herein heard Mr. is thus the learned counsel appearing on behalf of the petitioner. Mr. S.C. Kayal appears on behalf of the respondents number 1, 2, and 1 to 4. This court takes up the instant matter, instant proceedings for disposal with the motion stage. The order which this court proposes to pass. Now, in view of the order which this court proposes to pass, the presence of the respondent number 5 is not required. The petitioner herein, the grievance of the petitioner herein is that he had participated in pursuance to a notice inviting tender dated 1/5/2025 issued in the GEM portal for
Supply of bus money.
bus hiring services. Good stuff. The technical bid of the petitioner was rejected as was intimated to the petitioner by an email dated. Email?
Yes, not email, man. It's in the portal, my friend.
As was informed to the petitioner in the GM portal. To the effect that the documents uploaded by the petitioner were not found in order by the LPC as per the requirement of the buyer added bid oblique specific ATC. Got it, common point. The documents uploaded were not found in order by the LPC as per the requirement of the buyer added bid oblique specific ETC. We are covered page 15. The petitioner thereupon submitted various representations to the respondent authority. To re-examine the said tender process. The further grievance of the petitioner, which however was not done. The further grievance of the petitioner is that the petitioner was also not informed about the reasons as to what documents the petitioner did not submit, for which the technical bid of the petitioner was cancelled. Mr. S.C. Kyle, appearing on behalf of the respondent, numbers 1 to 4, submitted the report on the basis of which the petitioner's bid was cancelled. The grounds stipulated therein in the said report are quoted hereunder. The said document is kept on record and marked with the letter X. It is the opinion of this court that unless and until the grounds on which the petitioner's technical bid as above quoted are not challenged, the petitioner, the present proceedings cannot be. It is the opinion of this court that the grounds on which the petitioner has been disqualified has to be challenged. Under such circumstances, and in absence of a challenge, the instant writ petition would not be maintainable. Considering the above, this court therefore closes the instant writ petition in view of the grounds, report so kept on record and marked with the letter X and the grounds stipulated therein for disqualification of the petitioner. However, this court observes that the closing of the instant writ petition shall not prejudice the petitioner to challenge those grounds on which the petitioner's technical bid have been rejected.
Highly obliged.
You give a copy of this report.
I'll provide.
Has also been provided to Mr. S. Das by Mr. S.C. Kyle. The copy of the report kept on record and marked with the letter X has also been provided to Mr. S. Das during the course of the hearing.
I've already provided.
Provided.
Highly obliged.
Admission at 51, except 2 p.m.
My lord, in this case, my learned friend has filed affidavit on. Well, we filed the affidavit on
25.
on 20. But some
Affidavit filed.
Lordship,
on that day, my lord.
lordship in that matter, lordship, should I sub?
What did your affidavit say?
But basically, we said my lord, that there in 2014.
You want to file a reply?
Lordship, some points are there, lordships, which I have already annexures are there, page 49.
Mr. Mujumdar, do you want to file a reply or not? I'm asking you.
Lordship, I want to, because since he has.
Mr. A.M. Mujumdar, the learned counsel, appearing on behalf of the petitioner, submits that as the affidavit has been filed by the respondent number 4 only on 28/2025, he has to obtain instructions as to whether the petitioner would like to file a reply. He therefore submits that some time may be granted to list this matter on 15 September
Lordship, please. Lordship,
or early.
even Lordship convenience of this one.
No, I am always at your disposal would be the proxy.
15 and like that. 15 all
On
right, Lordship.
15th of September 2025. In the meantime, the petitioner will be at liberty to file the reply.
55 for orders.
Mr. Advocate General, we need your assistance in this matter. What has happened in this case is this. On one hand, you have issued a tender by which you are saying that you are going to give preference on certain aspects to MSMEs as per your procurement policy. But on the other hand, in the procurement policy, in the tender, you have put that the last 3 years of the annual turnover has to be 11 crores or above. Now, a micro industry or a micro enterprise cannot have 11. But on the other hand, you are giving preference. How do you gel both the situation? Normally, as I could see,
Just down. 10 crores.
well, what have you done?
Instead of 11, it has been reduced to 10 crores. The story is same.
Normally, what happens in gem portals, because you are due as per you have a particular Assam procurement and the procurement rules. Today in the morning, as I was just thinking about this matter, I was just going through the gem portals and all. You say that as regards the MSMEs, there's an exemption in respect to the turnover criteria subject to meeting the specifications. This is what is there in all gem portals. And you have a particular also, as per your procurement act or the rules, that a particular amount above, I think 10, 20 lakhs or something above, has to go to the gem portal. Isn't it?
There's yes. At 20 lakhs, if I am not, there's a finance department notification is there.
Now, if the gem portal has that, this is the only issue. How do you gel it? Because you see, as I was thinking, 10 crores, if you are just making it just 10 crores also, there is a big problem there. Because it starts from 0 to 10. How do you just put at the end? Either you should not have brought in the criteria of giving benefit to the MSMEs. Don't give it. But if you are giving them by putting it as a tender condition,
It's a spanner, this 10 crores.
you cannot have that. The only way out is you have to give up on the either that particular 4.12, which is that particular clause, or you have to say that as regards there will be there will be an exemption in respect of turnover criteria for the MSME, but subject to meeting all specifications, which is the GEM portal bidding process.
It depends upon the nature of work, in my humble submission.
Because
and also, if this criteria is there and there's a large number of bidders who are eligible, then this will fall flat, Lordship. That
I
10
understand. I understand. Therefore, if you see what NEPCO does in respect to the GEM portal, they put it that in respect to certain items of food safety, this is a food safety. There, the turnover criteria shall not be there. They put it, but they don't bring in the MSME. The problem is here you are giving them a preference. Because this matter I have been taking on a day-to-day basis only on the ground that this is for food supply, the dietary supply. And delay in disposal of these proceedings would have an impact on the supply chain.
Lord.
So that is the way how it is. Can we have it at 3 o'clock? You can think about it.
Lord, only
Huh?
thing is
Or
that 3:30 I have appointment with the governor. That is-
Okay, then what to do? Anyways, then I think we'll help it out with Mr.
He has this central government notification where earlier it was 5 crores, it has been substituted with 10 crores now.
Yes, now, if you read the parliamentary debates, this came into because of the budget given in 2025. When I was looking into that, when the budget was being placed, the reason why giving it is that they want to bring in more and more persons so that these people gets benefits. So it is from 0 to 10 crores turnover comes under micro. And 10 crores, one rupee to
It will go
100
small. It will go. And thereafter it is the medium.
So therefore, that is the problem which is being there. Because otherwise you cannot gel. You may have a 10 crore, but how do you have, as of now they say that they have doing it by a 10 crore, but how do you do it if you make it just 10 crore? Because it is 10 and they use the word symbol out there with a direction on this the other side, which means it's 0. From 0 to 10, anything comes under micro. If you see this clause, kindly see this.
Last,
Let me show you this clause 4.12 or what.
Close to 1 percent.
Yes, page 132.
But the end should have the meaning of the value of the tender. Value of the tender. Everything.
Then 214.
Yes, Lord, if the clause is there, but the list of items at 219.
The items are all food items.
Food items.
So I also understand that there is a requirement of having this, but how do you deal with it? The situation by putting in 21412.
Clause 4. That is the turnover clause, Lordship.
Now they have made it 10.
10.
But how do you make it 10 also?
Taking a cue from the central government's notification.
No. Central government never said that. Central government, what happened earlier, it was 1 crore, na?
5 crores.
It was 5 crores. Now,
They have subsidies.
the budget, they say, we want to include more and taking into account the market. Therefore, we want to give more advantage to the starter, to those micro, and therefore we have made it 10.
The only thing is that this basically is required for the purpose of finding out the financial stability. Because these are government supplies and the supply chain should not stop because of cost. And government bills also, it takes time for payment. All these things are taken into consideration.
Then you should not.
Sufficient number of bidders. Then I don't think this has anything to do. It is arbitrary or irrational.
No. Then if that be so, why did you put the clause out there in your tender that you are going to give advantage to the MSME?
MSME. So MSME also may have this average of 10 crores.
No, the moment it goes above 10 crores, it goes outside. That is the problem, na?
So minimum is 10. So that, of course, Lordship is absolutely correct. It comes to the next level. Then it's
So
small.
therefore, he cannot be, a micro cannot.
The either this clause should go or the other preference clause should
One
go.
has to go.
One has to go.
Both do not go.
Yes.
But therefore, I was saying in the GEM portal, they put it. And in GEM for NEPCO, what they do, they put out, they don't give this MSCB.
Mhm.
And for
also-
food products, they say that.
For this supply, you don't have to have an industry. These are purchased from the market and given. So for that, you don't have to have a manufacturing unit. So that also is not going on with this clause. Because this manufacturer of this, suppose rice or butter or condensed
No,
milk,
these are
they are
not-
not participating here.
No, no. These are all suppliers.
Suppliers.
These are
suppliers. So suppliers. Registration. So there are some benefits if they are MSCME. That one is that cost of the issue of tender, it is not imposed.
No, that they will get all these
Exemption
things.
from the earnest money and waiver of security deposit. These are
No, apart from that, by virtue of the 2006 Act, they would also get that you have to pay within a particular period
yes,
of.
yes. Otherwise, that interest,
That is a huge impact.
huge interest.
So this is a big one.
Mm. And preferences under the Act is Lordship, Section 6. MSCME registered under the policy and following scheduler will be entitled for price preference up to 20% over the L1 price. So these preferences are there.
You will give everything, but he has to first be allowed to participate. Problem is there. He has he will get a preference that not 20%, he will get 10. Huh?
So
Because
if
this
we
is
reduce
normally-
it to, if we further reduce it, Lordship, will it suffice? Then we can take a call on that.
No, only thing you have to say that you have to exempt them from that turnover criteria, but subject to specialization, the specification. That is the only way.
That will open up lot of participants and that will create, and if they are not financially strong, it will collapse the whole supply chain.
That all I understand. So you have to therefore either take out the entire thing, both, and come up that if food products no there.
Then let the matter be taken up. Lordship is not available. Otherwise, on Tuesday, I will discuss with the concerned authority and we'll take a call.
Because the Tuesday is the last date on, they have.
Then we have to give an extension then.
Huh?
We will have to give an extension of last date in that case.
There's no problem. I can take up the matter from Kohima also. There's no problem. If it's a partnered
Yes.
matter, I can very well take it
Yes,
up.
Lordship will pass an order with that observation that if it is 10 crores, he has a turnover, then they do come under the provisions of this MSCME. And therefore, there is a conflict with the clauses, two clauses.
No, I have passed that order. You see my last.
If that
order?
is there, then it will be easier for me. If the order is already
Take it
there,
up.
we'll take a call.
You show him, you will show him the order, what I.
No, because they have reduced it to 10, so date for that 10 will be sufficient. No.
You see, this
Yes.
court inquired with the learned counsel appearing on behalf of the respondent that if there is a Assam procurement preference policy 2021, which mandates certain preferences to be given, which is further incorporated in clause 4.12. And to be a micro industry, the turnover cannot exceed 10 crores. Is it within the mandate of the MSME Act as well as the Assam procurement policy to have the last three minimum annual turnover at rupees 11 lakh crores? So what they did, they made it 10. But for becoming a micro, it is 0 to 10.
Yes. So let me take a call. Let the matter be taken up on Tuesday. No difficulty, Lordship. Only we have to ensure, because if the competition is wider, it is better for us. But at the same time, we have to ensure that the person who will ultimately be successful
Therefore,
supplier.
in GEM portal, they have categorically turnover is exempted, but under the specification and standards have to be exact.
Not.
So that is what is
We
there.
want it to be a meaningful one.
Huh.
Tender there. We'll do that.
It requires an early disposal.
No issues, Lordship. We have 3 days time. In the meantime, we'll get it rectified. And with a corrigendum, if any changes are done, we'll give ample time for the participants. Because there may be other participants who would be willing to participate also.
Oh, there will be other parties.
Yes,
So you may
otherwise
have.
it will be prejudicial to them, those who have not participated, seeing this clause.
So there may be others also.
Yes. So it may create competition for him, but it will create competition for him.
Heard Mr. Also the learned counsel appearing on behalf of the petitioner, as well as also heard Mr. D. Soikia, the learned advocate general, assisted by Mr. K. Gogoi, appearing on behalf of the respondents. Should I bring on record the 10 crore thing you have made? No.
Yes, because that also is not solving the problem and it will not be in sync or in alignment with the provisions of the act.
So, pursuant to the order passed by this court on 21/8/2025, whereby this court put a specific ferry upon the learned counsels, upon the respondents, as to whether respondents, that if there is a Assam Procurement Preference Policy 2021, which mandates certain preferences to be given, which is further incorporated in clause 4.12, 4.1.2 of the bid document. And to be a micro industry, the turnover cannot exceed 10 crores. Is it within the ambit of the MSME, the Act 2006, as well as the Assam Procurement Preference Policy 2001, to have the last 3 years minimum annual average turnover at rupees 11 crores? Today, during the course of the hearing, Mr. K. Gogoi, the learned counsel, appearing on behalf of the respondents, produced before the court a corrigendum dated 21/8/2025, whereby the average annual turnover, whereby clause 4 of the additional terms and conditions of having average annual turnover of rupees 11 crores have been reduced to 10 crores. The said corrigendum is kept on record and marked with the letter Y. This court, however, this court, therefore, in view of the said corrigendum, this court further inquired with the learned advocate general as to whether reducing the annual average turnover of 10 crore to 10 crores would serve the purpose, taking into account that to be a micro industry, the turnover has to be up to 10 crores, which would include any micro industries below 10 crores. Full stop. The learned advocate general submitted that this is a contract, this is a tender pertaining to supply of food articles, and therefore would require certain regular supply of the food. And if the turnover, if certain financial credentials are not satisfactory, granting a contract may not be in public interest. He, however, the learned advocate general, however, submitted that he would have a discussion with the authorities in that regard and place and revert back to this court as to how clauses 4.1.2 of the general condition of the bid document can be reconciled with clause 4 of the additional terms and conditions. This court further takes note of that the last date for submission of the bid has been extended up to 26/8/2025. Full stop. The learned advocate general submits that the same period can be extended, and he would duly advise the authorities in that regard. Taking into account the statement, list this matter on, can we have it on 27?
Yes, Lordship. 27 is Wednesday, no difficulty.
27 at 2 p.m.?
Yes.
Because it will be through video conferencing.
No difficulty.
2
If Lordship meant at 2 p.m.
At 2 p.m. At 2 p.m. Full stop. The matter having been substantially heard, the registry shall post the matter and substantially heard, and the matter be shown as part of.
Not.
In view of the Advocate General's assurance that it will be done.
Can I get a copy this evening itself, this order copy?
Oh, yes, you'll get the copy. You give it to him.
Yes, Lordship. So that we can activate the process today itself.
Something
Before
has to be
26,
dealt
we
out.
have to extend it.
Something has to be dealt
No,
out
no, Lordship,
somehow.
no
Because
difficulty.
it's very difficult.
Because it must have overlooked or something like that. Highly obliged.
Production list, item 1, promotion, fixed at 2 p.m.
Motion.
Wait, please.
Oh, yes. Yes, Mr. Sharma, you are asking for an MLA's credentials?
This is highly improbable because the clause here is the head of the institution and the assistant executive engineer. MLA or the managing director of APTCL is not even required under the tender terms and conditions. And my instructions is that though we're not disputing, but if he is saying that he is not finding it easy to get the signatures, be that as it may, he may submit the bids and will not be insisting on those signatures. Because when I sought for instructions, they said this is not possible. Then I said, forget about it. Is it okay or not? He said, fine, we can do that. So
This
therefore, my
petition
instructions
has
are
2 ways out. When is the last date?
26th, 2 p.m.
2 ways out.
25th.
No, 20, holidays actually, yes.
There are 2 ways out.
Yes,
One
Lordship.
is taking your undertaking.
My instruction from the managing director, Lordship.
Taking your undertaking, I say that this should not be insisted.
Yes.
One. Or I can ask him to go to the executive engineer
Yes.
and get it certified and submit on 26th.
But my lord,
So what
this
is his
assistant
case?
executive engineer, APDCL, my lord, he is also not available in the office, my lord, for 2 days, my lord. He may obtain instruction.
Lordship
That
will-
is the problem.
Lordship will see.
They are avoiding us, my lord.
Wait. Lordship will see the clause. The clause says.
Where is the clause?
Page 17. Page 17.
Page 17, second paragraph, my lord.
Page 17. Page 17, the second paragraph.
Bidders must attach geotech photographs of visiting work site duly signed
Signed by
by
contractor.
self or their representative for assessing the site conditions before participating the tender and self-signed site certificate along with.
Yes, then the next line. The site's
Site
visit
visit
certificate,
to be signed by the head of the institution.
institution and
countersigned by the
countersigned.
Assistant engineer, executive engineer.
So the head of the institution is the institution head means the
Principal.
the principal of the Industrial Training Institute. Now, what is his case? He has filed two cases. He says the heads,
Two cases, my lord.
the other cases also.
Other cases also, my lord.
Now, what he says?
Two, my lord.
Now, Lordship, what he says? He says that the head of the institutions of Morigaon, Lakhimpur,
Lakhimpur
as well as in Moran,
Moran.
they are all in unison in not giving you the signature.
Oh, yes, my lord.
Is
He
it-
is
is it
saying
possible?
that, my lord, you obtain recommendation from the MLA.
Is it possible?
All are. That is.
And then the other person is the assistant executive engineer.
Let us not go into
So
those
therefore, I'm also entering into
Yes.
dispute.
that as he said,
Ah,
but it would be, we put it very clear that you cannot later on, because why the site condition visit is necessary.
Yes, my lord.
Later on, you cannot say that I did not visit the site.
No, my lord. It is
No,
photograph.
no,
I have.
I'm not on that.
Okay.
That I'm not going to believe also.
Yes.
I'm therefore putting it that that he may be permitted without insisting on this as per his submission.
Yes.
But later on, the petitioner cannot say that he did not visit the site.
Take advantage of that fact and say,
And also, the consequences for not visiting the site cannot be taken as a.
My lord. My lord.
I think that would be a fair order.
And photographs I have annexed, my lord. This is my lord.
this signature,
This geotech photographs, my lord.
Huh?
geotech photographs have been annexed.
Annexed.
It has to be otherwise certified, but the certification is not.
Certification
according
is
to
not
him.
given.
So we therefore give him that.
That without the certificate, he can.
My lord.
Without,
Certificate is there without the signatures of the officers.
now, without the signature, you would not insist on the signatures of them.
Yes, Lordship. Yes, Lordship.
That
Because he's saying it, he's finding it difficult to get the signatures.
photographs I am annexed. I went
And
there.
I don't want to dispute it because it's still his word against my word.
আর এটা আছে নাকি কিবা?
Only the
It
institution
is in
is
aspect of ITI
Moran.
and
Both are same petition.
no,
Same
my-
petitioners.
no, my lord, works are different, my lord.
No.
The item number one
Same and
is, my lord, boys and girls hostel in aspect of ITI.
Hmm.
And other is, my lord, the ST girls hostel of different districts of Assam, colleges, my lord.
এটা dictation দিতে মই আপনার কইদিম।
Clauses same.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. A. Sharma, the learned standing counsel of.
Respondent number 3, whether corporation is not a party, managing director is a party.
Ah,
Corporation is not a party, Lordship.
yeah, it is the managing director.
No, managing director.
Yeah.
APDCL managing director is not there. Anyways,
Yes, on behalf of Mr. Ardhar appears.
I am appearing for on behalf of Ardhar.
Miss So-and-so appears on behalf of the respondent number 1, then 3, 4.
Three for, my lord, principal, my lord, ITI, Moran and
Who appears?
no one appears.
No,
Notice
they are
have
not the tendering authority.
They are not the tendering authority. They just have to issue the certificate.
On behalf of the respondent number 1, and Mr. A. Sharma appears on behalf of the Assam Plains Tribe Development Corporation. The respondent number 2 had issued a discourse taking into account the dispute involved and the urgent nature of the relief sought for, takes up the instant petition for disposal at the motion stage itself. The respondent number 2 herein have issued a detailed notice inviting retender dated
2/8/2025, madam.
What is the date?
Actually, my lord, main date is published in, my lord, Annexure 1, that is 2/8/2025, and date is also 2/8/2025, but it is not mentioned in the
2/8/2025.
page 15 it is there.
page 15, madam.
15 it is there.
Dated 2/8/2025. For a page 17 of it to work, name of the project. Or when so construction of item. Or he to repetition of construction of item. The allegations in the same detailed notice inviting retender dated 2/8/2025. There is a clause mentioned which requires that the bidder must attach the geotag photograph of visiting work site duly signed by the contractor itself or their representative for assessing the site condition before participating the tender, and self-signed site visit certificate along with the bidding documents. The said site certificate should also be signed by the head of the institution and countersigned by the assistant executive engineer, APTDCL. The allegations contained in the instant petition is that the respondent number 2 is insisting upon certain recommendation before signing the site visit certificate. And as such, the petitioner has approached this court seeking appropriate directions. This court duly takes note of Annexure 4 and 5 to the writ petition, wherein the photographs of the work site of ITI Morigaon and photographs of the work site of ITI Lakhimpur have been duly mentioned, have been duly enclosed, along with have been duly enclosed. Mr. A. Sharma, the learned standing counsel of the Assam Plain Tribes Development Corporation Limited, submits that the respondent number 2 would have no objection in allowing the petitioner to submit the bid along with the self-certified geotagged photographs and would not insist upon
and site visit certificate, which is not countersigned by the other two persons.
Let me complete.
There are two documents also.
Mr. A. Sharma, the learned counsel, submits that the respondent number 2 shall accept the self-certified geotag photographs of the petitioner of visiting the work site and would not insist upon the certification upon the requirement of the signature of the head of the institution and countersigned by the assistant executive engineer APTDCL. If the petitioner duly submits the said along with the bid. Mr. A. Sharma further submits that as the petitioner's self-certified site visit certificates would be accepted, the petitioner later on cannot take any ground that he did not visit the site or there were certain shortcomings in the site. The learned counsel, appearing on behalf of the petitioner on instruction, submits that the petitioner would not take such plea at later stage. Taking into account the above, this court therefore disposes of the instant writ petition, thereby directing the respondent number 2 to accept the site visit certificates self-certified by the petitioner and without insisting upon the signature of the head of the institution and countersigned by the Assistant Executive Engineer APT DCL. This court further observes that the petitioner would be bound by the said certificate
Yes.
and cannot later on take any plea that he had not visited the site. If in the circumstance, the contract work is awarded to the petitioner.
Yes.
Here, my
That
lord,
is why this countersign is required actually.
my lord, respond number 2 is not insisting, but 3 and 4, principal is insisting to, my lord, go to the MLA, you take it.
No, the
Two is
the-
not insisting, my lord, 3, my lord, in the order.
Just now you said managing director.
No, my lord, principal,
How
IT and
did he
1.
say that?
Lordship, yes.
Yes, he said that.
MLA will be also of 3 different districts, Lakhimpur,
The
Morigaon.
other two
So this is why I'm saying it's highly improbable. This is what his grounds are. Anyways,
It is going on in the field, my lord.
oblige
Thank
you,
you,
Lordship.
And because of that, you have been able to come before the court.
Yes.
Otherwise, my lord, they will reject my technical people.
Daily list, item 21 for motion.
The liability is only data. Anna designers and consultants. Yes, what is this?
Lordship. Yeah, please. Lordship.
Yes, Mr.
Yes.
Tisokia, for whom are you appearing here?
I am appearing for the National Highway Authority.
National Highway now. Okay. What has happened? The sea buru and all. Anyways.
Yes. Before going to the impugn order, let me try to take your lordship to who am I? Here I am self-consultant, sorry, proof consultant. Now, proof consultant is, what is the role of the proof consultant? That has to be first amendment. That is there under Article 10 of the contract lordship. APC contract. Page 93, lordship.
So here you have been debarred.
Yes, Lord.
Blacklisting.
No,
Blacklisting is like.
like that only. What happened, Lordship? Who am I? This is very important to understand, Lordship. Now, I am not a party to the agreement. Now, my appointment as a consultant, that obligation has been cast upon the contractor.
Contractor.
On the contractor. Now, that is why the obligation that has been casted upon the contractor to appoint me as such, that is referred in Article 10 of the agreement. And again, I reiterate, Lordship, I am not a party to the agreement. That is page 91 that starts from. 91 of the writ petition, Lordship. Lordship got it? Yes. The important thing, Article 10, obligation prior to commencement of work. This is very important. At the very top of page 91. Then, that is thereafter 2 pages after, Lordship, under Article 10.2. That's where I fit into. Now, it says design and drawing. 10.2 subclause 2, Roman 2 laws, at page 93.
Page 90.
93. Before that, Lordship will come at page 91.
91 is obligations prior to.
Prior to, this is very important.
Then
And then there are, I mean, like the
Design,
contract.
10.2.
Yes, 93, 10.2.
shall appoint a proof check consultant.
Exactly.
After proposing to the authority a panel of 3 names of qualified and experienced firms from whom so and so shall propose to the authority a revised panel of 3 numbers of so and so. The contractor shall also obtain the consent of the authority for a and shall evolve the system approach with the design directors for minimize the time required final design implementation.
It is also important, Lordship.
Okay. So you mean to say this is a contract between NHIDCL or NHI with the contractor?
Contractor. That's
And
what
the
I was
contractor appoints you as a proof consultant in the manner stipulated in clause 10.2 Roman 2.
Roman 2. And Roman 3 is the duty cast on me.
Evolve a system approach with the design director so as to minimize the time required for final design and construction drawing and proof check the so and so. Okay.
That is, again, prior to commencement of work. You know, that's there. And secondly, see, now I am not in the payroll of the authority. I am a mere consultant. I am a professional.
Now, what has happened here?
What happened here, Lordship? There's an untoward incident happened near the Baihata location also. What happened? A girder fell down. A girder means like while lifting the big iron sort of things, and human casualty happened. Thereafter, I mean, so-called notice were issued to me.
Let's see the so-called how it is.
Yes, that's important.
Yeah. I think 340.
Yes.
And various forgivings of by the
Yes. Instead of 5.6, they have invoked the clauses.
Point. And where is this particular NHI's policy circular?
Pardon?
Policy circular of 2021.
They have basically invoked, Lordship.
No. Where is the policy? NHI policy circular dated 8/1/2021. At page 341, there is a reference.
That has not been provided to me.
This is available everywhere. This has to be your basis, Mr. Dekka. This has to be your basis by which you provide that you see what has happened is this as it appears. 10.2.3 says that what is your work. 10.2.4 and A, the contractor shall prepare and submit with reasonable promptness and such sequence as is consistent with the project completion schedule, 3 copies each of the design and drawing duly certified by the proof consultant to the authority engineer for its approval. Provided, however, that in respect of major breaches and here the authority engineer may require additional drawing from so and so. By submitting the drawings for review and approval, so and so, the contractor shall be deemed to have represented that it has been determined and verified that the design and engineering, including the field construction here, are in conformity with the scope of so and so. Now, on the basis of this particular document, you can see as to whether the NHAI has any role over. Now, something must have happened in the bridge where you had given some certification.
No.
Yes.
No.
You had to give
That is-
certification.
that is a good question here. Now, what happened? My role is over. The moment before commencement of the work, my role is limited to vetting and reviewing the design. That is before the commencement of work.
Therefore, you see,
I am not obligated to supervise.
Yeah, it has been, no, if something is wrong with the design,
that has not been raised. That has not been raised.
No, this is what it says.
No.
It is the submission that does not seem to be factually, the year it say, and so and so. It is to note that the above submission does not appear to be factually correct as on the date of the placement, no crane has been seen and one excavator and so and so. Understood that the launching of the said grider has already taken place before so and so the date of the incident.
Yes.
Further, as per the report of the FDU so and so by letter dated so and so, the submission of the team leader has been stated to be not correct. In view of the above facts and circumstances, the authority by way of the present supposed notice for non-fulfillment of the contractual obligation under so and so agreement requires from the proof consultant so and so to show cause as to why appropriate action should not be taken.
Lordship.
Now, what is your reply? Let us see. Evolving, so it is important that approval's role is strictly limited to checking the design and drawings and does not extend to construction site activity. We have duly reviewed all relevant designs, documents based on the order as per the RPF, the contractor is responsible for preparing and submitting the designs and drawings to the so and so. These drawings are then forwarded to the authority engineer for approval. The proof consultant involved is restricted to design and drawing review, and no responsibility is assumed for activity occurring at the time of construction of the site such as here. Now, what is the reason given here?
Okay.
In view of the fact the so-called noted, Khanna had submitted a reply and so with regard to the reasons leading to the compliance and death of one of the not invent, do not justify the actions of the other consultant, however, review the project design and drawings as per the specification and standards schedule D.
Lordship.
Submission of the contractor incomplete work method statement for launching methodology in so and so failed to implement the protective measures at grider area as they were working in seismic zones 5. Use of is the obligation of the proof consultant to ensure the enforcement and review of the design parameters, review of the work.
Yes. Lordship, yes. Very important to note here, the paragraph 3 and 4, which has been repeated. That was repeated in the Sogos notice and that was repeated in the impugn. What happened? They have stated findings of facts. Now findings of facts, they have denied, and those findings of facts, I am not privy to. Now, who is the team leader of TPF engineering? That is the system is like that, Your Lordship. The respondent number 8 and 9 are appointed as authorities engineer. Now, authority means the chairman and a chair. He's engineer. Basically means outsourcing. They are to supervise. I'm not here to supervise. I have no authority, no obligation, in fact, to intervene.
So your role is only to certify the design and drawing.
Exactly. That,
Now, if your case therefore is that if they say that in view of any defect in the design and drawing, there might be something. But that is not the case in their show cause notice.
No, not
Or even in the order.
in the impugn order.
That is your case.
Yes, and my vetting, it's basically like reading as proof the design, and that has been previously approved by the authorities engineer. That's where my role is finished.
Yes, Mr.
I do not have the complete instructions, but from the impugned order, it is very clear that it is the obligation of the proof consultant to ensure enforcement and review of the design parameters, which he have failed. So
But where do you get that? Because then
even prima facie, I could not find it out. Let me be very honest. But Lordship may kindly give me a very short time so that I can bring the instructions. On what basis they have said this? What is the obligation about his
Because it
regular
It
reviewing?
appears, Mr. Saikia, the prima facie appear that his work are twofold. First is that the final designs are made
Yes,
within the minimum time he has to look into it,
Lordship.
along with the design director. This is the first rule. The second rule is proof check the detailed calculations, drawings and designs which have been approved by the design director. And 10.2. Roman 4a says that he has to certify the designs and drawings. So now the question is, if there is a defect in the design and drawings too, whatever, but is it that the order does not, however, say that, but it says that you knew about it in the suspect pipe zone, and why didn't you ask this grinder to be there and all this thing? He has nothing to do in that regard. But anyway, I'll do one thing. As is an order passed on 9/6/2025, he has approached now. I'll issue a short notice
Lordship.
so that you file your reply,
Lordship.
and then I think we will take a call.
Lordship.
Limited prayer laws. In the meantime, since I may be allowed to apply, because my name is only suggested.
Apply where?
I mean, like various contractor, they suggest my name.
Mr. Dekar, kindly appreciate one thing. You have approached this cause after 2 months. Would it be fair on the part of the support
Lots.
pass an
Lots.
interim order today?
Lots.
8 to 11, all dates are over. Let's have it on 16th.
Lordship.
Issue notice making it returnable on 16th of September 2025. Union? K. Gogoi. You, anybody, union? You are standing counsel or not? No, then Mr. K. Gogoi accepts notice on behalf of the respondent number 1. Miss K. Devi. Huh? Accepts notice on behalf of the respondent number 2, 3, 4, 5, 6. Who is 7?
7 is the contractor.
And why you're making the other two?
Other two are the authorities engineer. We have no claims against him, but since we have referred to their findings of facts on that day.
But how are you going to effect service so soon?
Basically,
Problem arises with these two persons. The 7 I can take care of by asking you to.
8 and 9 not necessary for the purpose.
Not necessary. Extra copies of the writ petition be served upon them by Tuesday. As regards the respondent number 7, the petitioner is directed to effect service by way of registered as well as usual in the address mentioned in the state of Gujarat. Further to that, taking into account within 3 days. Further to the, by Tuesday going. Further to that, taking into account that the respondent number 7 also has an office at Patsala in the district of Balaji, Assam. Bozali, Assam. This court directs the petitioner to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. They have an office.
They have an office.
So you can serve it there, na?
Listen. No. So I respect it. At least some more time in that case. In that case, not only 2 days or 3 days.
What?
For dusty service, Lordship. You said, Lordship said.
I am asking you to file the affidavit of service on or before the next date.
Oh,
the petitioner herein is aggrieved by the action on the part of the respondent NHAI in blacklisting the petitioner for a period of 1 year. That is from 9/6/2025 to 8/6/2026.
9/6/2026.
9/6/2026. It is the case of the petitioner that the petitioner is was engaged as a consultant. Where is that page 19? Consultant. Proof consultant. And the role of the proof consultant is only limited to evolving a system approach with the design director as to minimize the time required for final designs and construction drawings, and proof check the detailed calculations, drawings and designs which have been approved by the design director. It is the specific case of the petitioner that the petitioner has no role during the period of construction. Be that as it may, on when did the incident happen?
Yes, on 28/2/2024.
An incident occurred at Baihata location on NH27, wherein a grider, GIRDER, fell, causing a casualty of a local vendor at the construction site. On the basis thereof, a show cause notice was issued to the petitioner on 21/2025, seeking response from the petitioner as to why action should not be taken against the petitioner. Which resulted in the incident which took place on 28/2/2024. A reply was thereupon submitted by the petitioner on 31/2025, clearly specifying that the petitioner has no role to play in while carrying out of the construction execution. However, that same was not taken into consideration in the proper perspective. And by an order dated 9/6/2025, the petitioner was blacklisted for a period of 1 year. The learned counsel, appearing on behalf of the petitioner, drawing the attention of this court to clause 10.2, Roman 3 and Roman 4 of the tender documents, submitted that the ground on which the petitioner was blacklisted could not have been done so, taking into account that the grounds which have been mentioned is completely outside the purview of the petitioner, who was only engaged as a proof consultant. He therefore submitted that the ground on which the impugned order was passed is nothing but malice in law and requires an interference. Full stop. Mr. D. Saikia, the learned senior counsel, appearing on behalf of the respondent, NHAI, submits that at paragraph number 7 of the impugned order, the grounds have been duly mentioned as to why the petitioner have been blacklisted, have been debarred for a period of 1 year by the impugned order. Full stop. These are technical aspects which requires to be more simplified by way of instructions, and therefore submits that he would like to, the NHAI would like to file an affidavit in support of the grounds. Full stop. He therefore submits that the affidavit would be filed by 8th of September 2025. Full stop. Taking into account, Mr. P.S. Decker, the learned counsel, appearing on behalf of the petitioner, though has submitted that the impugned order requires that the petitioner is entitled to certain interim directions. But in the opinion of this court, taking into account that the petitioner has approached this court after a period of more than 2 months, it would not be proper on the part of this court to pass an order without taking into account the instructions from the respondents. Accordingly, this court shall consider the instant proceedings again on 16th of September 2025. The petitioner is given the liberty to file a reply upon the filing of the affidavit by the respondents. Full stop. It is observed that if no affidavit is filed by the respondents, this court may pass appropriate orders on the next thing.
If I may take a slight liberty, Lordship.
Yeah, please.
Item number 54 supplementary, today's list. Identical case, same incident. The case is of road safety consultant. They have obtained the interim order after notice. So in that case, I have to file affidavit. I have just received the instructions. I'm paying for 2 weeks time for filing of the affidavit.
I'm appearing in.
Both the cases may be tagged together. Same clauses, same so cause notice, and identical impugned order.
But there is an interim order there.
There is an interim order because that interim order was issued after notice and without filing of the affidavit.
In order till disposal of the writ petition.
Interim order was passed after due notice, just like what Lordship has done. It was filed a long time back, and the interim order was passed on 24/7/2025.
Okay, item number 52.
54 supplementary.
Okay. Item number 54. You have not filed your affidavit.
No, we'll file in 1 week's time.
Okay. Mr. D. Soike, the learned senior counsel, appearing on behalf of the respondent
Same.
NHAI,
Yes.
submits that the affidavit respect to the instant proceedings will be filed by on or before 8th of September 2025. Liberty given to the petitioner to file reply, if so advised. This the matter on 16th of September 2025. Along with WPC number Interim order may be extended.
No, that is.
Oh,
okay,
it is there?
disposal.
You would not, because I extend it till your next date. Highly obliged.
Applies for them.
Item 22.
But devoter.
Disposal. Twenty-three is also similar. Similar devoter matters. I provide.
23 and
24. My lord, this matter relates to two petitioners here. My lord, the number 2 has got a transport business. He is having transport. Two of the vehicle which carried coal from Meghalaya to the destination, to the last destination, Gorakhpur mile, and she was carrying all the documents, the vehicles. But suddenly it was stopped here by one of the police station for no reason and right.
What?
And they detained the vehicle, and we produced all the certificates of origin and whatever certificate duly signed by the government. All this has been produced before them. They are saying, no, we don't want to leave you. I said, give a Caesar list. If you have done something, give a Caesar list. They are not releasing the vehicle. For what purpose they are not releasing the vehicle, we don't know. What is the reason behind? Legal notice has been sent, and we said, please release the vehicle. You give the reasons. You want to keep this vehicle, give a reasons to us. No Caesar list, nothing as on date.
What are you carrying?
The coal from Meghalaya. And that is the scientific way where it was extracted and we carried. Kindly see all the bills.
Now, who is doing this problem?
I'm sorry, the Assam police
What is the
here.
problem?
The police, Assam police,
Page 58.
What do you know?
Of the code. 58 and 59 is source of.
58 and 59.
Source of the code. in the trucks, which is-
Source of the coal and the truck, 58 and 59. These are the two vehicles. '58 and 59. These are the two vehicles, kindly see 59.
And they have not given any Caesar list, nothing.
No, nothing.
We don't even know why this is.
We don't know also, for what reasons. We have showed all the documents to them. But they are not releasing it.
Take instruction, madam.
It's seized on 8th.
Seized on 8th August.
Why are you approaching so late?
No, we have, my lord, all the time we were approaching.
No,
And
11th we issued a legal notice.
11 we issued a legal notice.
We kept saying it back to us, but never got back to us.
11th we issued a legal notice. They were giving us lot of hopes that we will, yes, we'll return back the vehicles, but today, till today, they have not done anything.
They had to get some verification report, which is not.
So have you mentioned what is the loss felt by you because of their actions?
We have not mentioned.
No.
We have not mentioned.
Any damages.
No, we have not claimed any damages as on date.
Because we didn't.
We'll do.
How
For
much
what?
loss has you are facing daily?
Yes, correct.
How much?
Daily ki man kare for loss.
No, because the vessel is not reached its destination, so I do not know how it will be damaged.
So damage.
It reaches the 10 days or 15 days later.
Damage is different. How much loss you are facing daily because of that?
We-
These are consignments sent from
Meghalaya
Meghalaya
to the original place, Gorakhpur.
Gorakhpur. Now, these are on the basis of some contract.
Yes, yes, correct. It is contract.
And if it is on the basis of some contract, you are to supply within a particular.
Yes,
period
right,
of time.
absolutely.
And if you don't do so, there might be certain damages.
Yes.
Yes, but we can't access it till the.
Now-
Then we will ask the police officer to pay, na?
My lord, let
They
me take
have,
instruction,
otherwise
because
a lot
my
of
lord,
money.
there is here, my lord, statements are there, my lord, but I'll have to take instruction, my lord. Why it has, because no, nothing, no document is, my lord, annexed in the writ petition, though they have stated clearly that no FIR, nothing has been lost, my lord. So regarding seized, my lord, seizure of those vehicles, my lord, I'll have to take instruction, my lord.
Because you can't seize like this. You have to give a seizure memo or something. If it has been done on which date it was done?
8 seized.
August. The vehicle was released on the 6th from Meghalaya.
At least he has to pay the rent charges.
Reason for
In the railways, they call it the demurrage charge.
Yes.
You quantify and file an additional affidavit next day. We will ask that person concerned, the in charge as well as the respondent number 6 and 7 to pay that amount.
Yes, sir. We will do it.
Then they will understand each day of delay what it impacts upon the common citizen.
illegally, that should not be. But what is the reason, my lord, I may be allowed to place the, my lord, reason for?
Definitely, you have a good
Procedure.
right to keep everything.
My lord.
This can't happen. Heard Mr. Issue notice making it returnable on 1st of September.
My lord.
1st of September. Or 29th, can we have it on 29th?
My lord, I'll try, my lord.
On 29th? Can we? On 29th of September 2025. Miss Yuda, the learned additional's senior government advocate, accepts notice on behalf of the respondent number 1 to 6.
Action.
As regards the respondent number 7, the petitioner is directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. At this stage, this court is not inclined to issue notice upon the respondent numbers 8, 9, and 10, which shall be considered on the, if so need be, at a later stage. The petitioner herein are transporters, na?
Yes, transporters.
Are transporters carrying on the business of transportation. While carrying coal from Meghalaya through on the in 2 trucks bearing registration number UP 51805553 and UP 22804371. The respondent number 6, na?
6.
Who has 6? 6 have held those vehicles and have not permitted those vehicles to proceed to its destination. The case of the petitioner herein is that the petitioners have duly provided all the necessary documents. But the respondent number 6, for reasons best known, have not only released the vehicle, but also have not even issued any seizure list.
Yes.
The learned Mr. B. Das, the learned senior counsel appearing on behalf of the petitioner, submits that in order to hold on to those vehicles and not allowed to proceed, the same has to be done only by following the due process. However, for reasons best known, the respondent number 6 have not allowed those vehicles to proceed And it is under such circumstances, the respondent number 6, the respondent is number 7, who is discharging the functions in the capacity of the respondent number 6 have been arrayed by name. He therefore submits that this is he therefore submits that the petitioner on daily basis is incurring losses and the contractual obligations have also been and is incurring losses. Taking into account the above, this court directs the respondent number 1 to 6 to provide instructions as to on what basis the two vehicles have not been allowed to proceed to its destination. On the next. Pending
We'll file
notice,
additional affidavit.
pending notice, comma, it shall not be a bar on the part of the respondent authorities to release the vehicle.
Liberty is going to file an additional affidavit first.
Why?
To give a chart, what is the damage that has been caused to us?
Your lookout.
Please give a direction that
You don't do that, and then when I point out, then now you think that you file. I'm not going.
we will file it.
I think they will release it by
We'll
then.
file it. Yes, extremely.
And if
Deeply
you don't have anything, release it.
Malat, I'll inform today itself.
Yes, what is this? Chiku Enterprise. Yes, what is this?
Here, Lordship, the petitioner's bid was rejected on the ground that he uploaded the document from the same IP address from by using which another firm also uploaded the documents, Lordship. Because of same IP address, his bid was rejected.
Who is paying for the central government?
That rejection, your Lordship will find page 263, annexure 5.
Who has done this?
This is done by Lordship. Respondent number 2. That
You have problems with Oil India, na?
Lordship. Lordship.
And why Oil India is not a party?
Lordship, that MMO is the party, Lordship. Material Management Officer who issued the NIT, Lordship. He is the party. Respondent number 2.
You most probably don't do a lot of RIC matters, I suppose. Huh? We'll have it on some other day.
Right.
And you make a submission that you want to make Oil India a party. And I'll allow you to make that submission and ask you to file a fresh memo of parties. Better, na? Because without oil being made a party, you cannot succeed.
Lordship.
Isn't it?
Lordship.
The tender has been issued at the instance of oil.
Lordship.
The legal counsel appearing on behalf of the petitioner submits that inadvertently the petitioner have not included. Who has issued the tender?
Respondent number 2, Lordship.
Respondent number 2 cannot issue the tender. Na? ONGC, na?
ONGC.
You have to make ONGC. Inadvertently, the Oil and Natural Gas Corporation have not been arrayed as a party to the instant proceedings, at whose behest the tender document was issued. He therefore submits that he may be permitted to add Oil and Natural Gas Corporation Limited as a party to the instant proceedings. This court further takes note of the materials on record, and from the materials on record it transpired that the said notice inviting tender was issued. The notice was issued in the GEM portal for and on behalf of Oil and Natural Gas Corporation Limited. Accordingly, For the, so this court, therefore, in the interest of justice, impledes the respondent number impledes Oil and Natural Gas Corporation Limited having its office at who appears for ONGC normally? Yes, you. Where is its office? Nazira. Having its office at Nazira.
ONGC Assam Asset Nazira.
Is ONGC Assam, na?
ONGC Assam.
Assam Asset Nazira.
ONGC Assam Asset Nazira. Represented by its managing director?
Mal.
ONGC Assam Asset represented by its managing director having his office at Nazira. Pin code you just find and give it as a party. Oh, wait, you got it. ONGC Assam, this is Sipsagar.
Sipsagar. But ONGC's head office is at Bombay, my lord, Mumbai. Can give the ONGC's head office.
No, let us have it. ONGC Assam Asset Sipsagar.
Yes.
Assam Asset Sipsagar. Represented by its managing director as a party to the, as respondent number 8 to the instant proceedings. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days and by Tuesday. Tuesday. And on the basis of the same, the registry shall make necessary changes in the course title and update the same in the CIS. This court is also aware of the fact that the ONGC has its standing counsel. No.
ONGC doesn't have a standing counsel. They have a panel of counsels and it comes from Nazir.
Okay. List the matter on next Tuesday, Friday?
Thursday, Lordship, if possible. Thursday, if possible.
Why Thursday? This is the matter again on 29th.
Problem.
Otherwise, you could have to file an application on Tuesday. Then an order would have been passed on Friday. And then the matter would have.
50.
Yes, Mr. Chaudhary.
Regarding cancellation of allotment in industrial estate matter, because of huge area matter. So lots you will find at page 106 matter the impugn order.
How much you have been asked to pay?
Yeah, earlier also, there was a judgment of this honorable court, I have annexed this judgment. Under the act, there is no provisions for revision of the rent, regarding the unit. But in the judgment itself, it was challenged and it was held by this court that the government has, and although the provisions are not there, the government can fix. Hereafter, it was fixed, exorbitantly, and then it was pending, thereafter another writ petition was filed, challenging the provisions of the act. In the meantime, there was a sitting, and your lordship will find at page 90 the minutes of the proceeding. The industrial units representatives and government and corporations officials said together, then in the minute some resolutions were taken,
How much you are paying?
As per my calculation, it comes to 28 lakhs, without interest. The 99 lakhs inclusive of 18% GST and 18% compound interest. That is why 99 lakhs that has come out. So, my lord, I may be given some time, my lord, already I have paid, my lord, in through installment as per minutes of the proceeding, 10 lakhs I have paid, my lord. So 18 lakhs I can pay at present, my lord, at least 2 months time will be given, my lord.
For what?
My lord, to pay the amount, my lord. And the other issues, my lord, regarding exorbitant, etc., I have challenged here, so till that decision is made, my lord, my lord, in the meantime, I will pay the amount, my lord, without interest, that actual part of the rent, my lord. I have annexed the case, calculation sheet also regarding inclusive of 6% interest. If it is calculated, it comes out to 28,67,000. At page 116, my lord, I have annexed, my lord. From June 2007, my lord,
What are you challenging? Which document you are challenging?
my lord,
Page
page 106, my lord.
106.
Yes, sir.
Cancellation of the allotment of open space.
And shade area, my lord. We submitted several representations, my lord. Shade area is also dilapidated and it is not for its use.
You propose to settle the matter at 50 lakhs.
No, my lord.
This
It
is what is mentioned there.
We
And
have
the
said, my
board
lord.
of directors having not agreed, they say that we are entitled to 99
My
lakhs.
lord, this is, they say, my lord, no records are there, my lord, regarding that I proposed, my lord. I did not propose, my lord. It is there.
And your unit has been non-functional.
No, my lord, I have submitted my representation up to 23, my lord.
No, how do your unit is functional? Show me.
Up to 2023, my lord, we were functioning, my lord.
No, so
During-
it has not been functional for the last 2 years.
Yes, my lord.
Then why do you need a space?
Now, because of, not my fault, my lord. Because of waterlogging, etc., we have submitted our representation for not functioning, my lord. Why it was not functioning, we have stated, my lord.
No stay, no stay.
My lord, only with respect to that, my lord, regarding taking over possession, my lord, that part may be.
That has to be. You are not functioning.
No, my
This
lord,
is an area which is.
we are functioning only because of waterlogging, my lord. Only because of waterlogging and the.
So then why you are there? Go somewhere else. You cannot occupy. Somebody else will use it. Think about the others. You don't pay. There's an outstanding of, as per you, 50
It is
lakhs.
not only in my case, my lord.
As per them, 99 lakhs. And now you have not been functioning from last 2 years. Why on earth should this court pass on your order?
My lord, it is non-functioning only because of their own fault, my lord.
Whose fault?
The corporation itself, my lord. It has not, the site has not been maintained, my lord. The shade allotted to us, that is also dilapidated condition. It is not for use, nothing, my lord.
And the site was allotted to you when?
My lord, since 1994, my lord.
Oh.
And it was.
You already enjoyed
before the
and
act.
since
of-
when have you not paid?
2007, my lord.
Huh?
Since 2007, my lord, regarding rent, my lord, the writ petitions are going on here and stay was there, my lord. And in 2000,
Earlier judges were good.
your lordship may kindly see the minutes of
There are
the.
two options. Earlier judges were good. Second, I am not so considerate. Third, next week there is a good judge. With an adjournment. I am not going to pass this type of order. This is, for me, this is a case for dismissal writing. No considerations.
My lord, at least, my lord, I will be given opportunity sometime, my lord.
For paying 50 lakhs.
So that.
50 lakhs they have not
Already,
accepted. And you said
already,
this court that you are going to pay
already 10 lakhs I have paid, my lord.
These two peanuts. And first of all, you should vacate. You have not been working for 2 years. So therefore, you are not functional. Let it be used for some other people. There are people who are dying to have that.
I am also, my lord, since 1990, it is continuing, my lord.
But you are not working from 2023. It's not. There's no quarrel with that.
There is no situation at all, my lord, for functioning, my lord, at present.
You cannot have that land.
My lord, its shade has been allocated, that is dilapidated. and the space that cannot be used because of water logging, my lord.
We're happy to have it in 1994 and you still be happy to keep it. Otherwise, why are you insist on keeping it? Tell me, you are not working for 2 years. Why are you insisting?
My lord, during COVID period, my lord, your lordship.
COVID is finished. COVID is,
Now,
the sea is also not there
my lord,
anyway. Even the latest
this
variant
said
come also has not.
setback came to the company, my lord, after the COVID, my lord. And at present, my lord, I will pay, my lord.
Pay 99 lakhs, then obviously.
99 lakhs, my lord, it is inclusive of 18% compound
If you
interest.
don't pay,
That
no
is-
stay. Isn't it?
No, because in
No
this
stay.
case
She's
itself,
opposing
20
nail.
since 2023 is not occupying, since 2027 is not paying.
At least, my lord,
2007 you have not paid.
no, my lord, I have given the judgment, my lord. I have an next also.
Judgment is
But
there.
the criteria,
Judgment is for you to
My lord,
assign it before the
in the-
division bench.
there is-
Here, the judge even didn't
there
consider.
there is no provision in the act itself, my lord, regarding such amount of fixation of rent. The Urban Area Rent Control Act also, there is something limitation. my lord.
Well, Urban Area Rent Control Act, the moment you apply, then section by virtue of section 5 you are withdrawn.
That will come, but the act, act excludes, my lord. Town Planning Act and the Urban Areas Rent Control Act acts are excluded.
So then you come
Only
under what?
because only just regarding, my lord, the fair rent, my lord, I am saying, my lord. The
Fair
fixation of
under what?
fixation of the government, my lord, that has to be done in accordance with the
Yourself
observation done.
say that 50 lakhs we are going to pay. And this is what has been
No,
mentioned and they have not
That is
accepted.
their version, my lord. After minutes, my lord, it was the resolution of the minutes, my lord, that we should pay through installments. But it was not fixed, my lord. Regarding rent fixation, that was they delayed, my lord.
Who
That is
appealed
why.
from Assam Industrial Infrastructure Development Corporation. Yes, you are there. I know some, I don't know. There were 2 persons. One is Mr. Munir appears for somebody.
We have 4 units.
Huh?
We have 4 units.
Ah.
Some small one is that AIDC.
Now, who appears for Assam Industrial Infrastructure? Then give him notice. So, Mr. S. Samaria is being the standing, you are standing counsel?
Yeah, man.
Being the standing counsel, appearing on behalf of the respondent number 2, submits that no copy of the petition has been provided to him. List this matter again on next Wednesday, 27. Copy of the petition be furnished to him. Bad.
It's for 3 and 4.
No, I'm not issuing notice, nothing.
Madam, he is appearing
My
for
conscience, madam, notice is not fit.
Madam, yes, for 3.
No, let him receive for days. He only submits that no copy has been.
Kindly, my name may be shown, my lord.
And the name of
My-
Mr. S. Samaria
my
is
name
shown
of-
in the call.
My lord, my name is also not shown in the cause list, my lord.
Yeah, it's still appearing. That I think yours, when you take care.
Item 20, order for recruitment.
Whom do you want to implead?
Ministry of Jal Shakti. Contempt petition.
Whom do you want to implead?
Lordship, Ministry of Jal Shakti and Promoter Board.
Huh?
Ministry of Jal Shakti.
Borsing Rongpi.
Yes.
Only one or how many?
One is retired and 2 is transferred, Lordship.
No. Whom do you want to implead? I must
Implead Ministry of Jal Shakti and Promoter Board.
has retired and so and so and so and so has retired. Now, whom do you want to implead? I'm asking you.
I want to implead Ministry of Jal Shakti, Lordship.
Respond number 6 and 7.
Yes, Lordship.
Huh? Mr. Counsel, you want to implead whom? The chairman Brahmaputra board.
Ministry of Jal Shakti.
How can the chairman of a Brahmaputra board be the contemptor?
Lordship, kindly see page 18.
I'm asking you page 7. How do you implead the chairman of Brahmaputra board without buying in name?
During the pendency of the writ petition,
I know what has happened. Then you want to implead 7 is
Ministry of Jal Shakti.
Ministry of Jal Shakti. Can Ministry of Jal Shakti be a party in a contempt proceedings? Don't make this court laugh. The people who would be issued notice also may laugh. What is wrong with the High Court? Withdraw, file it, find out those names. Who is the chairman of the Brahmaputra board? Who is the concerned person in the Ministry of Jal Shakti who has not done? Okay? Yes. The council appearing on behalf of the petitioner submits that there are certain defects in the instant application, so that for which he would like to file a fresh application. Taking into account the above, the instant application stands closed on withdrawal. However, the petitioner would be at liberty to file a fresh application.
For admission item 26.
Yes, Mr. Ghosh.
This case, my lord, I have approached lordship for cancellation of my fair price shop license, my lord. Now,
Affidavit filed?
affidavit file everything. We have also filed our reply, my lord.
Very well. Then
My lord will file, I'll take my lord to this, my lord, the impugn order.
don't take me out unless there is an urgency out here. Don't take it because I have to pass and sign the order. Anyway, otherwise, I have already passed very long orders. Unless you have urgency that there is a requirement to have it, we'll have this after vacation. Because before vacation, there is no time.
Yes, I understood lordships. Only a date may be fixed then, my lord.
List this matter, taking into account that the pleadings are complete and Mr. B.J. Ghosh appearing on behalf of the petitioner submits that the petitioner's license have been cancelled.
Yes, that is.
Yeah. And there is some urgency. List this matter on 4th of November, 3rd of November 2025 at the admission.
My lord, the month of my lord, the October or something.
No, October is closed. You can't.
My lord, late,
of
September, my lord.
Okay, we'll have it on December, 1st of December. 1st of December. Next.
27.
3rd of November?
It is lordship.
Yes, what is this?
My lord, it pertains to
Again, another one.
my lord, this pertains to non-payment of contractual dues. My lord, on the last occasion, my lord was pleased to direct the respondents 4 and 5 to submit.
It therefore shows that this
gentleman,
client of yours,
My
or
lord.
your gentleman, is very much doesn't want to leave Mr. H. Burawa.
My lord.
Whatever may be.
My lord. So, my lord.
Even for a purpose of recall also, he has.
Twice, not twice.
Yes, what is it?
My lord, on the last occasion, your lordship was pleased to give a direction to the respondent 4 and 5, my lord, Assam State Corporation to submit the details, whether I am entitled to the.
Yes, have you provided?
Yes, my lord.
Yes, my lord,
They
we
have
have
submitted
given.
an affidavit. And they have admitted my claim and the work that I have completed on time, my lord. There's only one difficulty, my lord. Here, my lord, they have submitted my bill as well as my lord, the proposal to the Agriculture Department, my lord, what I could see from the affidavit. And the Agriculture Department, on the basis of the documents submitted by the Assam State Corporation, including the bill of all the contractors who had submitted, who had who worked under the, my lord, the concerned project, my lord, they have sanctioned, they have given a fund of only rupees 31 crores.
Who?
My lord, the Assam State Corporation had proposed that on the basis of the documents that they have collected, that is, my lord, the bidders like the petitioners, a total amount of 31 crores for paying the contractual dues of the contractors, my lord, they have submitted a proposal for 31 crores to the Agriculture Department to release the payment. Now, my lord, Agriculture Department has, after verifying those documents, has, my lord, released an amount to the tune of only 21 crores. Now, that release order, I have already annexed in my writ petition, and that has also been annexed here in the affidavit. There, the items that I have supplied, my lord, the two variety of speech that I have supplied was not included in that sanction order, my lord. Now, because it was not included, the remaining, my lord, the parties or the bidders who were there, my lord, they have released the my lord, the payment to the other bidders, excluding the case of the current petitioner, my lord. If your lordship may kindly come.
How much you entitled to?
I'm only entitled to, my lord, 23 lakhs and some odd, my lord.
But that amount is not there.
That amount is not there.
And it is submitted that in the fund release order, the director specified indent against which payments we made, but the fund of AR required against the indent in respect to a petitioner had not received till date.
Yes, my lord.
As a result, due to non-receipt of fund, payment could not be made. Now, that means they duly accept.
They accepted, my lord.
And you have not made the payment to Assam Seeds Corporation for which you have not been able to. Is it?
They have to answer.
Yes, my lord.
Have
They
you
will-
looked into the affidavit?
That's why I don't receive the.
Mr. Samaya,
I will.
interdepartmental problem.
Yes.
Okay, Ms. G. Bora appearing on behalf of the Agricultural Department submits that though an affidavit has been filed by the Assam Seeds Corporation on
Was on 21/8.
21/8/2025, but she is not aware of the contents as no copy has been served. She would therefore, Mr. S. Samaria submits a copy thereof would be served upon, a copy would be served upon her. First of list this matter again on 19th of September 2025, on which day the Agricultural Department shall prize this court as to when the amount would be paid to the petitioner, taking into account that the amount of rupees 23 lakhs
And 51,500, my lord.
51,500 have been duly admitted by the Assam Seeds Corporation Limited. And for want of funds from the Agricultural Department, the said payment have not been made to the petitioner.
I'm highly obliged, my lord.
What is this?
Your lordship, this is regarding a demolition of unauthorized construction.
Oh.
The GMC council in the last hearing said that 19 August has been fixed as for demolition. But only part of it has been demolished, and I have given the copy. I waited for next day, but they didn't come up for further demolition to complete it. So I have written to the authorities that only ground floors has been unauthorized construction, ground floor has been demolished. Only so your
Lordship,
lordship
as
go
per
through this.
our instruction, Lordship, the ground floor has been demolished and the rest of it is underway, Lordship. That will also be demolished. In one single day, Lordship, that is a lot of.
There was 4 units in the ground floor, lordship. Only 3 has been demolished, 1 is still pending. And I have given the copy to the GMC and this is the receipted copy. And in the last paragraph, I have given a suggestion, your lord.
For the respond number 3, we newly engaged. Accordingly, I gone through the record of the court's record. It reveals that the GMC passed an order on 13/5/2025, whereby our appeal has been rejected. Although it is marked to the respond number 3, but this copy was not served upon us. Even we inquired to the office. They have refused, did not say that nothing was communicated. That copy, I just gone through the court's record. I was not provided to the copy of that order also.
So
Malad, can it be Malad so that
has it been demolished or not?
Without
Lordship,
hurrying
yes,
upon and-
almost done, Lordship. It's underway.
Finish it off.
And your lordship, I want to suggest that in the previous council has got the copy of this order, what he is saying.
No, he himself told me. I remember this matter when I took it up. It was on 1/8 when Mr. N. Alam was appearing.
Yes,
He
yes.
said that we have accepted this and we have no objection to the demolition. What do you say, Mr. Goswami? You have not been instructed properly. And when a matter comes before this court, I remember what has happened. And therefore, Mr. N. Alam, who appeared on that day, said that. Kindly look into the video in YouTube. You will find out what he said when this matter was taken up. So don't come up with all these pleas before this court.
So in fact, the ground floor has already been demolished.
So we impose a cost upon you for making a false statement before this court. This is not a thing which you should have done. No, Mr. Goswami, this is not that you have not received a copy because this person concerned, Mr. N. Alam, on very, you were there.
Lordship.
He very well said that we have received the copy and we have accepted
Lordship, in
that
fact, they
there
had
is no
taken
problem in
they had
demolition.
submitted an affidavit wherein they said that they would themselves demolish
They
the.
were themselves demolished. This is the stand which is being taken and now you come up before this court. Say this.
Just now I gone through it. That is why.
No, it is not gone through you. When you are engaged out there, you should take proper instructions. This is what was the submission made. Okay, when are you finishing the demolition?
Lordship, 1 week time.
Okay, Ms. So-and-so appearing on behalf of the GMC submits that the demolition is ongoing and would be completed in a week's time.
Lordship.
List this matter again on 5th of September for an update.
Your Lordship, my suggestion may be included that the notice should be placed on the tenants' notice so they can vacate it. Most of it is vacated in third and fourth floor, but as I have narrated in the letter, the respondent is persuading them not to vacate so that he can longer on the delay the process. So I will request you, the this council, to say the GMC person to paste a notice on this.
Saying that they are completing in a week's time.
Okay.
If it is demolished, where they will go there, we are not bothered. Let them come. Somebody may file a suit. Go there.
29 and 30.
Much obliged.
May it please your lordship. The lordship would like to further.
Mr. I. Chaudhary, yesterday in one matter, I've asked you to appear in this court. That would be on 18th of September. The reason why what has happened is that matter, some counsel from the state of Arunachal Pradesh has appeared. The issue involved therein is the drivers in Arunachal Pradesh, they don't have, either they are not provided the MSCP or they don't have avenues for promotion. So that is an issue which is applicable, filed for the Guwahati High Court. But the fact remains is that the moment they will get it, it will get, or everybody will get it. So therefore, I say that the Advocate General's presence would be required. So it is on 18th. 18th. So ask your counsel. Yes. Now, what is it?
Lordship, we are awaiting some instructions from the client. So Lordship may kindly give us further 4 weeks time to file a reply against their affidavit in opposition. In both item number 29 and 30.
Affidavit in opposition filed on 6/5. You want to file reply?
Yes, madam.
Can you stay?
There's no stay, madam.
Huh?
There's no stay.
Oh. The counsel appearing on behalf, no problem. The counsel appearing on behalf of the petitioner submits that they would like to file affidavit in reply. List these matters only after the affidavit in replies are filed.
Much obliged, my lord.
31 and 32.
These two matters relates to a reconstitution of an petrol pump dealership, my lord, in one of the case. And in another petition, the subject matter is, my lord, there was a, my lord, some repairs has to be done, whether it is to be done by the company or by the dealer. And as per the, my lord, company's own circular, since it is in the dealership of an scheduled tribe person, my lord, it is the company who has to undertake that exercise.
So there is a interim order.
Yes.
No urgency?
No, but we have to file
No, my lord, there is urgency on our part because from August 2023, my lord, we have not been able to function, 24.
So,
but it is their duty, the dealer duty, to construct the wall, as per the guidelines,
No, my lord,
They have annexed one paper, which is not part of the record also,
Gosar, my lord. Okay.
No, my lord, that is not
Have you
correct.
filed the affidavit? No. No, my lord. We are going to file, my
You
lord.
don't want to file.
No, no, we will, in this matter,
That's
we
a pretty
we are
long
going to file,
matter,
my
my
lord.
lord.
Huh?
My lord,
he-
if there is
he is
some
not
urgency,
objective, my lord.
let them take 10 days time, my lord, let them file the affidavit.
Lordship, I'm preparing for item number 32 in this matter. So Lordship, in item
31 and
Oh, sorry.
32, in regard at 32, I'm for the respondent number 4 in this matter. So we've already filed their affidavit of opposition against their petition, and they have also filed
No,
their.
no, company has not, corporation has to file it. Okay.
next one, we
They have filed a reply, but I don't have.
has
the copy
filed?
of
Okay,
the
we'll
reply.
give a copy of that.
She has filed.
As she has filed an affidavit to which we have filed a reply, she says she has not received the
We have
copy of
not
the
been finished
reply.
with that.
We'll furnish, madam,
by tomorrow.
tomorrow.
Mr. S. Thakur, appearing on behalf of which company?
Hindustan Petroleum Corporation.
Hindustan Petroleum Corporation Limited submits that the affidavit in opposition would be filed on or before 10th of September 2025. First up, Mr. Ken Chaudhary, the learned senior counsel, expresses urgency in the matter, taking into account that the petitioner have not been
Operate since August 24.
or have not been able to operate since August 2024. Taking into account the above, list this matter on 23rd of September 2025, liberty given to the petitioner to file reply.
In the meantime.
In the meantime.
Develop.
Interim order passed earlier shall continue.
33,
Interim order passed in the interlocutory application. Huh? Non-payment.
Yes, ma'am.
Admitted, not admitted.
Admitted.
Verification.
There's
carrying on.
There's a communication attached, my lord, in the petition.
I'm asking you, admitted, not admitted?
Admitted.
Verification.
Verification, my lord.
Verification 6 months. Dispute.
Obliged.
34,
May please your lordship. My lord, 34 and 35 are similar matter, my lord.
My instruction is awaited, my lord. This is the second time it has come. Let it be on 8th of my lord of September. Let it be on 8th, my lord. At least the admissible part, my lord.
Do you know how many matters are there in 8 and 10? Lots and lots and lots.
On 10,
Like it would be happening like yesterday. I had 9 matters at 2,
lots.
7 matters at 10:30.
But on
So
10th,
don't put it any further.
10th also. 10, 9.
Okay. Oh, these people have not been released the security
Security deposit
deposit.
money, my lord.
My goodness.
Let my instruction come, my lord. Already communicated.
Contractual
Okay,
due has been
matter.
paid, my lord.
New matters, okay, we give some time. Mr. B. Gogoi, the learned additional advocate general, submits that he would like to file an affidavit. The PWD would be filed. PWD
Yes, we did finance.
be filing the affidavit in the matter. Pusto. It is the Pusto. Taking into account the above, list this matter on 17th of September 2025. Pusto. The affidavit be filed by 10th of September without pay.
Lots.
Obliged, my lord.
35,
Same.
37,
Order has been passed but not cancelled, madam. Only madam, warning has been given. madam.
Oh, this figure we looking at was transferred, so he could not obtain the, oh, yes, what?
Madam, they have not cancelled it, but madam, warning has been given that in future.
So thing done, see.
Yes,
should
madam.
feel
Yes.
happy
I am happy.
Yes, madam.
Because notice.
No, now the question of suspension no longer remain.
Madam,
Yes.
because already.
Yes, ma'am.
For the provincial survey and on being done, I go and so hereby reinstate the suspension of human and last one and not to repeat.
Already reinstated the suspension.
We keep this.
Madam, that's why I've given the orders.
It has been submitted by Miss Yudas, the learned additional senior government advocate, that pursuant that an order has been passed by the Court District Commissioner Lahorigarh, whereby the suspension of the petitioner have been revoked.
My lord, yes.
And
Reinstated.
and the proceedings which were initiated under section clause 15(2) of the Assam what?
My lord,
Articles of distribution,
Of the
Assam Public Distribution of Articles Order.
distribution of articles
Orders,
order
1982.
1982 have been closed against the petitioner.
It's not
with-
clearly, that is not stated clearly. Lordship will find the last para of the letter, my lord. So reinstate, hereby reinstate the suspension of, reinstatement has been done, my lord. The suspension has been, my lord.
Revoked.
Good job.
Yes, yes. Reinstate.
Yeah, you say, we reply with a so-called reply.
So was reply.
So reply is
Satisfied with that.
satisfied. So there were nothing remains because
My
the
lord,
thing is what to
suspension,
be-
yes, reinstated, but
No,
further
the
proceeding,
words are not so proper.
my lord.
But you see, from the above communication
Yes,
and on being satisfied with the show cause reply,
My lord,
I so and so hereby reinstate
the suspension of,
the suspension of so and so
my lord,
with one and last warning,
my lord.
and not to repeat the so and so, and if any discrepancy found in near future in connection with the distribution
will
license,
be
license will
cancelled.
be cancelled. That means he's not cancelled.
Further, they will not proceed further
The
with this.
stern warning that if any discrepancy is found in near and future, in connection with in near future, in connection with the distribution of NFSA rise, the license would be cancelled accordingly. So taking into account, so the said order dated, what is the date?
Date, my lord.
28/2025, isn't it?
Yes, my lord, 20.
28/2025, as well as the instructions so produced by Miss Udas, the learned additional senior government advocate, is kept on record and marked with the letter X. In view of the reinstatement of the petitioner and the dropping of the proceedings initiated under clause 15(2) of the so and so order, nothing further remains in the instant proceedings for which the writ petition stands closed.
My
Appears on behalf of so and so.
A copy of the.
Take this. I put it as X. A copy.
lord, I'll give him.
You need actually my order.
Oh, yes, that's what I don't know.
That order is more there.
Yes,
Because
sir.
what
And-
language this
Yes,
court
sir.
district commissioner have done is dangerous.
My lord, that's right.
Very difficult.
Probably, my lord, petitioner has already received that money.
Maybe I am.
You need this one.
My lord.
MA Sheikh, where is he? Mr. K. Gogoi. Executive officer, who is the area so and so. Oh, yes. Where is this? What has happened here? Type copy of the comparative statement. Mr. Why it has been submits that here? By the secondary of human whereby the bid is higher than
Yeah.
but for no good reasons, the beauty market has been given. What is the name of the petitioner?
Premal Brahman.
Premal Brahmo.
Here, my.
Prem-
Mr. K. Gogoi.
Premal Brahmo, yes.
Premal
yes,
Brahmo.
yes.
My lord,
Premal Brahmo, yes, not submit. Earnest money, not submit.
No, my lord, your lordship, I have filed an additional affidavit, my lord. So I annex that
no, my lord, this.
bank draft, my lord,
Nobody has attacked the.
at page 38, my lord.
He didn't know.
No, it's okay. They have filed an affidavit, na?
No, my lord.
Affidavit has been filed by Premal Brahmo. In that case, by somebody.
Lordship,
Additional affidavit filed by the petitioner.
Yes, my lord.
So you did not submit the earnest money.
Yes, my lord, I have annexed this at page 38, my lord. I have deposited, my lord. Your lordship will consider that I have not submit earnest money. It is overwritten, my lord. If your lordship not agree.
Is it?
Yes,
Lordship,
but, your
my
lordship
staff,
will see,
Ah.
it is overwritten,
this is my staff.
some tampering.
Minus of the tender committee meeting, Lordship.
Default certificate in Xerox.
My lord. So, my lord, regarding that, my lord, my reply will be,
Cooperative society registration.
your lordship, at page
Mr.
20.
Sheikh, I think you should file a reply.
My lord.
Oh, this additional affidavit has been filed by you.
Myself, my lord. Your
How
lordship.
did you come to know about all these things?
This comparative statement, my lord.
Huh?
My lord, I filed an application. I filed an application at the time of filing the writ petition. They did not supply, and subsequently, my lord, that was supplied. Now your lordship will turn to serial number 20, page 37 of my additional affidavit, my lord.
Yes.
They say that yes, Xerox copy submitted. My humble submission before your lordship, Xerox copy I have submitted. They can call for the original. They can call for from me. That cannot be the ground for rejection, my lord. And now your lordship, regarding registration certificate, my lord. Registration certificate I have annexed with the additional affidavit.
Given to whom?
Not
Rahul-
up to date.
Rahul Brahma.
Rahul Brahma, lordship.
Yes. What happened, my lord?
Though comparative.
I submit the bid, my lord, personally. But they wanted for the certificate of registration certificate, my lord. That I have submitted, but they said that it is not up to the mark. Your lordship would be pleased to see the certificate.
Not up to the mark, they know, not up to date.
Up to date, yes, my lord. Your lordship will turn to page 40.
Page 40.
Yes, my lord.
40. Hereby certified.
নামটো কাৰ আছিলে? কানাড়া বেংকৰ
2001.
ক্লিয়াৰ আছে নেকি?
Anno Damini. What is this?
এইখন দিয়কচোন চাওক ওপৰত। এইখন চাওক। কাৰ নামত আছে নামটো চিনি নাপায় দেখোন।
আছে, অৰিজিনেলটো আছে মোৰ।
অৰিজিনেলটো কওকচোন।
এই প্ৰেম বৰ্ম এইটো চাওক।
Mr. We do one thing. Ask them to produce the records.
Yes, my lord. Entire record may be put.
Record, and you also produce the registration certificate original.
My lord.
Original registration certificate.
Original registration.
You have it?
No, my lord, here regarding registration certificate.
No, because Mr.
My lord,
Mr.
only
Singh,
thing, my lord.
No, Mr. Singh. This is a original, this certificate, if you can read it, I think you should be getting what?
My lord.
Some of the awards which are given by the president. Right? Nobody can read it.
My lord.
Madam, can you read this?
No, lordship.
Nobody can read it. Can you read it? Nobody can read it. You
In additional affidavit, my lord, additional affidavit, I have given this photo, translated copy, my lord.
That is why,
Copy, my lord.
that is why,
Yes, my lord.
because of the fact
My
what
lord.
date is
I'll
being
produce, my
mentioned,
lord.
because the mood, their basic case is not up to date.
Not up to date.
Now you see 2nd of March in the year 2021, Anno Damini. What is that?
2021.
Anno Damini. What do you mean by that?
After Jesus Christ, my lord, this is the word written, my lord.
List the matter again on Miss R.B. Bora appears on behalf of the Musalpur, na?
BTC lordship.
Appears on behalf of BTC as well as for the executive officer, Musalpur Municipal Board. Full stop. This court taking into account the minutes of the tender committee meeting have been produced during the course of the hearing. Full stop. This court further is of the opinion that taking into account the additional affidavit filed by the petitioner, it would be necessary that the records of the proceeding, records of the tender in respect to Musalpur bi-weekly market be perused. This court therefore directs Ms. R.B. Bora to instruct the executive officer, Musalpur Municipal Board, to produce the records. Further to that, the petitioner is also directed to produce the original of the registration certificate, which is one of the grounds on which the petitioner's bid was held not eligible List the matter when?
A short date may be given.
Short
madam.
date.
1 year supplement only.
September,
Can you produce it by 5th of September?
September.
ETC is nearby.
Yes, my lord.
Musalpur is how far?
Then also lordship, our second week lordship.
Eh?
Second week lordship.
Second week. Second week, okay. The second week, no time. 17 September.
Lordship.
Yes.
Deeply obliged.
39.
Interim order passed earlier. Will be filed. But what is this matter about?
This is tender matter, my lord, issued by IG Prisons for food and supplies, my lord. So they were, for June 4, there were two tenders. One was rejected and I became the qualified, my lord. Then subsequently they have cancelled the tender.
It's in the process of the development. You have filed your affidavit.
Well, we have filed the affidavit. Our decision is at page 97, my lord. 98 is the relevant. On two grounds, my lord, the tender has been cancelled. Firstly, the single tender, and second is, my lord, we found the rates are unreasonable. The comparison of the rates we have given, my lord, at page 95.
Anyways, urgency.
Urgency is there, my lord, because we have not. my lord,
Have it
my lord,
next week.
One submission I have, my lord.
No, Miss, let's have it on 27.
No, I have a submission, my lord. My lord, the rates we found are excessive, and then they said that there is a possibility of some negotiation if they agree, my lord. Because the rates are unreasonable if kindly comes to page number 95 and 96, my lord. We found, my lord, page 95 kindly take.
What did you find?
The market rates are, we have given present wholesale market rate. These are we have taken from the concerned authorities.
This is who has given?
Limos.
Huh? Petitioner has given.
No.
That's absolutely.
These are
the L1.
These are the evaluation, the records from the records we have given, and these we have taken from the concerned authorities, my lord.
Petitioner is what? Lumos.
Lumos Infra. If lordship kindly comes to, lordship will find, my lord, the present wholesale market says it is 2,000. Rate is 2,000. They have quoted 3,400.
There are some rates, my lord, which is more,
second
some
is
is less. So they say that they want to negotiate. And in fact,
So
my lord,
they want to cancel. They have cancelled
they
it.
cancelled it. Now they want to negotiate, my lord.
You have issued a fresh tender.
Yes.
My lord, lordship has directed us not to proceed. So they said that there may be an.
If it is, you think that it is excessive.
Yes,
obviously you are at liberty. Proceed.
And lordship has said not to.
Oh, can I not pass any order?
Mala.
Proceed. You see, the amount they are putting at 16,000, which should have been 11,000, it's too much.
No, not all rates, my lord. Not. I'm saying that, my lord.
No, this is some.
No,
lordship will say. Just for example, rice common, your rate is 4,450.
Yes.
Present wholesale rate is 3,800.
But lordship will also compare it. I made a comparison, my lord.
Kindly see, my lord.
Comparison last year tender, the rate was 4,000.
This is where?
No, this is I'm calculated from the
prisons.
Prisons.
My goodness, no, you cannot have so much in prisons. You don't give good quantity.
Page number 96, kindly see.
It cannot be. One prison is already in my head.
Same authority.
My lord,
kindly see, 96, page 96. Present market rate is 900. They have quoted 4,800.
Because lordship, they filed affidavit, I think of 20th. 20th, my lord. I want to file a reply also, my lord.
Reply, but I'm vacating the interim order.
No, lordship will.
Vacating.
Lordship will hear me, my lord.
The tender of dietary products cannot stay. I'm very particular on this. You participate. Submit press tender. If it is excessive as per them, how is this court going to look into that it is not?
Lordship will hear
As
me,
per
my lord.
them, we have to believe.
No, we-
They are the tender calling authority.
No, Lordship will see the comparison I made it, my lord. Of course, my client was not there, my lord. But I have found that rice, like my lord, last year, last tender was 4,000 rupees, my lord. So, but we compare to that, our rate is little bit high because of the inflation, my lord. And there are some price items which prices are less also, and they have more. So that is comparatively, my lord, the prices are, my lord, 7-8% inflation will be there, my lord. Like 16,000 lordship has said, but last year.
Then the reason which is assigned at Annexure B is justifiable.
No,
Justifiable.
Lordship will see, that last year also, a person who became the L1 bidder.
See, if there is no reasons, it's a different thing. But if they have a reason, question does not arise.
No, Lordship will see that Lordship just says, as said, 16,000. Last year, the rate was 16,000 quoted, my lord. So it is not that 16,000 is higher, but they have considered L1 bidder.
Not getting money. I think you must be adding the interest, no? Because when thereafter you will file a writ petition and the court would not pass any order for interest. After
No,
3 years.
Lordship will take it on Monday or Tuesday, my lord, or Wednesday. I'll file my reply also before that, my lord.
You want whenever, but I'm not going to extend the interim.
Then
my conscience does not permit with these justifications.
Lordship will say that there are two tenders, my lord. Now they said we are the single bidder. Actually,
Single bidder, it is not possible.
No, Lordship, there are two tenders, my lord. One is technically disqualified, and one is, I got qualified, my lord. Then instead of, if that be the reason, my lord, then they should not have opened my price bid, my lord. They should have gone for the retender, my lord. Then I can understood that, my lord. They can cancel my tender, my lord. But not after making me qualified in technical bid. Then they often gone and opening the price bid, my lord.
So
There is a judgment, my lord.
The technical bid. No.
Technical bid, I was qualified.
So that is why they opened.
No, because that means they are went ahead, my lord, and there was any negotiation, my lord, that has to be done with the L1 as per the CVC guidelines also, my lord. So they could not have gone for retender, my lord. My question is that, my lord.
But single tender?
Single tender, as per the judgment of my lord, I'll place the judgment, my lord.
What?
Huh? Court record, there is judgment, my lord. I'll just place, my lord, our High Court judgment, my lord.
Single division?
Single judgment, Honorable Justice Ujjal Bhai has passed that order, my lord. Page para 22, my lord. The judgment, Devendas, my lord. Lordship will.
Very good ground for filing an appeal. That this judge did not listen to me and did not look into a binding position. Fantastic ground of appeal.
I leave it to Lordship, but then, my lord, let me place my facts, my lord.
Fantastic. I have seen it. Whatever may be, single bid. And then this is the rate quoted. Not.
Rate quoted, that's what I said, my lord. I have compared the rate, my lord.
Forget about comparing the rate. Look at
Earlier tender, my lord. Earlier L1 tender, my lord. My rate, my lord. And the present rate, that, my lord. And they want to negotiate the rate, I have no objection to that, my lord.
So go negotiate. They are happy to negotiate.
Yes.
You go ahead.
Lordship will keep it pending, my lord.
Close the petition, negotiate. Negotiate. You want to negotiate with him with the rate.
They can.
That means you are withdrawing the tender. If you are
Since
you are
we have been,
going for negotiation, you are withdrawing the tender.
we have urgency.
There cannot be both. You see, if you want to negotiate, means once you have cancelled it, that means you are revoking your cancellation. Otherwise, you cannot negotiate.
But in view of the interim order, Lordship has directed us.
Forget about the interim order. I'm not on the interim order business. But the fact that if you want to negotiate with him means there is no stay to the cancellation.
And if at all, my lord,
what is stayed is invitation of the bid.
Not to proceed with the
invitation of the bid.
Lordship.
That is the only thing which has been stayed.
Lordship.
Now, if you want to do, means you want to give up your cancellation, then the tender automatically falls.
The
But you cannot be put. We know normally the government courses you, but here you have been coursed.
Well, they are of the view, Lord, that since we are not in a position because the urgency is there, these are
I
directly item.
understand the
Lordship,
urgency.
Lordship. So that is why they said that if Malad, they can explore the possibility for having that. Malad.
How
That-
can
that's all.
it be
That's all.
possible unless you withdraw? You withdraw your cancellation. And once you withdraw your cancellation, his bid already becomes active. And therefore the fresh tender goes for a 6. Isn't it the consequences of all?
True.
The question of negotiation does not arise. So we need to do one thing, vacate this type of orders. But with these reasons, I don't think you should. Question of negotiation does not arise.
Malad, it is clear from our side that the rate quoted by him is not acceptable to us.
If it is
So
not
that is why we have
or
rejected.
then he
And
cannot
since
compel-
Malad, since
he cannot compel you that he should
That's
get.
true. That's true.
If your reason is that to the effect, no.
Yes, this is our region, Malad. We are very firm on that. Only because the urgency, considering the urgency,
When did you file the affidavit?
we have filed the affidavit on
Day before yesterday.
20, long time back.
Today is 22.
Huh?
23.
Today is 22. These type of matters are on daily basis, hourly basis.
But we will file a reply immediately, my lord. On the next one.
India councils like you
No.
charge on hourly basis. Now you are saying on daily basis.
We will file it on the next we'll file our reply on the next working day, my lord.
But I'm vacating this type of order.
Lordship will see the comparison, my lord. I have comparison, my lord.
The thing is, you see, they have reasons. The reasons are such, this court is not going to touch it.
My learned friend has made a comparison, my lord.
Becomes easier.
Of course, that is not final, my lord. We have just.
Comparative previous rate. Now this time rate is 10% higher. Arahar, 11,000 market price. Previous rate here. Masudar. So you admit this to be the market price when he is making this comparison.
I'll file an affidavit, my lord, to that.
Then if that is the market price, then giving you at such a high rate obviously cannot be a justification.
It is not acceptable to us.
Gur, molasses, 5,500 market price. Previous year's rate is 9,900 and this time is 9,500. You have lessened it down. Maybe the production of gur must have come up more.
But there are rates, my lord, up and down, my lord. I don't.
Up and down.
Like
Okay.
mustard oil, my lord, we
I am
170.
not inclined to hear.
170, my lord. The previous rate was 188. We quoted 200, my lord. Then, my lord.
Okay. We do one thing. You make a submission to extend, I reject the submission to extend. I'm not satisfied. With this affidavit, I'm not satisfied. After all, it's a question of public interest.
Therefore, my lord, one day, my lord.
Participated or not in the new tender? Participate. Again, fight out. Because you see, this is the conscience of the court does not permit. And if I don't pass an order also today, it is vacated. So you can't take an adjournment also. You are in the catch-22.
Lordship will.
Mr. Roy.
My lord, I'm not saying that. I'm not. So there are, my lord, but the rates, again, my lord, the lordship will say.
No, Mr. Roy, kindly be more considerate enough. Come up with you see, this is too high and they have reasons. And once that thing comes in the affidavit, means it is, I don't think any court would also said anything with these rates are there, which are there to page 95, 96.
I admit, my lord, some rates are more, some rates are less. But we have taken the inflation on account, my lord, then we quoted the rate, my lord.
You have put the inflation or whatever, market price still remains the very less.
No.
When they, yes. you
In
see
some
this.
item, my lord, lordship.
Now kindly see these, all prices. Like Matikalai is the best part. Market price is 10,500. Last year you have given at 9,800 and this time you have put it at 11,000. That is the best. Chalo. What do you want? Oh, I'm not extending it.
My lord, you keep it on Monday, my lord. or
I'm not
Tuesday.
extending it. Monday, Tuesday, you want the next year also. I can give you whatever date is, but I'm not extending it. The moment you make that submission, kindly extend. I am the moment immediately I reject. And make it fast because we are running out of time. But this is the final conclusion of my order. I'm not extending. Earlier, when the notice was issued before the court did not have the reasons. Now with these reasons, it becomes very difficult for the purpose of interfering with the decision-making process. And it's absolutely within the prerogative. And what about the Assam procurement there? Which stipulates that when there is only single bidder, you have to go for a fresh tender. That's the law.
That is correct, my lord. If they would have been not opened the price bid, they would have gone for the retender, my lord.
Oh, for that, go to the civil court. What loss you have felt?
Like some of the rates, I'm saying they're squash, my lord. Market rate.
What do you want?
Market rate is 5,000.
You make the submission for extension for me to reject.
Lordship will give one
I gave
chance,
you.
my lord.
You want
Like Tuesday, my lord,
the counsel appearing on Mr. J. Roy, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit in opposition filed by the respondents. The learned counsel further submits that the interim order which was passed on 8/8/2025 be further extended. This court have heard the learned counsel on the interim prayer, on the extension of the interim prayer, and have also further taken note of the affidavit in opposition filed by the respondent number 2A. It is relevant to take note of that at the time when the interim order was passed on 8/8/2025, there was no reasons available to the petitioner. This court were not apprised of the reasons why there was a decision to go for a fresh tender. And it is under such circumstances, the order was passed directing that the retender process shall not be proceeded with by the respondents without the leave of the court. Pursuant thereto, an affidavit in opposition has been filed by the respondents. It is very pertinent to herein to observe that the tender in question is in respect to supply of dietary articles under Zone 4 jails. Jails of Assam during the financial year 2025-26. Under such circumstances, there is great urgency in respect to dealing with, in respect to concluding the said tender process. This court further takes note of the reasons which have been assigned in the affidavit in opposition, and more particularly from the minutes of the minutes. Where is that? Minutes. And more particularly from the minutes dated 22/7/2025. It is further seen from minutes dated hence. The reasons were assigned is that the rates which were quoted by the single bidder, by the single eligible bidder, what is it?
Unreasonable.
Unreasonable.
No, before that,
Tender has
has been reversed.
Only single tender.
and was qualified
No, as qualified.
as unreasonable.
Well, unreasonable rates. This court further takes note of Annexure B to the said affidavit in opposition. The Annexure B to the said affidavit, a perusal of the Annexure B to the said affidavit in opposition shows the rate quoted by the petitioner in the erstwhile tender, quoted by the petitioner earlier, and the wholesale market price, present wholesale market price.
In the present tender, they have quoted this rate.
No, that is why.
Yes.
Now you have gone for a fresh tender, no?
Yes, we have gone.
So
On the same
Cancel tender.
on the same terms and conditions.
Yes.
The difference in the rates as shown in Annexure B and as appears, the difference in the rates quoted by the petitioner vis-a-vis the present wholesale market price in the opinion of this court, the decisions so taken in the decisions so taken from a perusal of the rates quoted by the petitioner vis-a-vis the present market wholesale price, the decision of the tendering committee that the rates are unreasonable rates cannot be said to be unfair, unreasonable, arbitrary, or perverse. It is further relevant to take note of that the state, it is also well settled that merely because there is a single bidder, the state is not bound to allot the tender, allot the contract if the bid so submitted by the single bidder is unreasonable and arbitrary. Consequently, this court, in view of the stand taken by the respondent number 2 in 2A, is not inclined to extend the interim order. List the matter on
Wednesday, my lord.
Huh?
Coming Wednesday, my lord.
On
Tuesday we'll file affidavit, my lord. Wednesday, madam meeting.
27th of April 2025 as requested by the learned senior counsel.
Not to extend polemic.
Item 40.
Interim order passed earlier, stand the key.
Not.
Oh, yes.
My lord, the tender has been cancelled.
Yes.
We won that item, my lord. We won that particular item, my lord. So we have cancelled the tender.
Better.
Yes, we won that, my lord.
See? No, because you have to put
Yes,
that.
you'll have
Otherwise
to
it becomes
indicate
very
it.
difficult also.
My lord.
And luckily we kept in a very short date.
Yes, my lord.
Otherwise, Mr. B. Gogoi, the learned counsel appearing on behalf additional advocate general, submit that the tender in respect to the present petition which is the subject matter of the writ petition, have been cancelled by the cancellation notice dated 6/8/2025. The same is kept on record and marked with the letter X. Taking into account the above, the learned counsel appearing on behalf of the petitioner submits that nothing further remains in the instant proceeding for which accordingly the writ petition stands closed. Interim order stands vacated. Yes, what is this? 40? What? 52.
Last order, they were directed to submit a report.
Yes, any amount, what is your? Is he entitled?
My lord, a certain amount has been paid to the petitioner, my lord, earlier. My lord, and there is a list of, my lord, due to non-availability of the fund, my lord, many other other persons are also there. And so could not make the payment, all the payment, my lord. So we have to file the affidavit, my lord.
No, we pass an order, you pay within 6 months.
My lord, other
And last
persons.
year-
also-
See, Kamsar Ali
My lord.
does not come in.
My lord. My lord.
So we direct you in view of this, the full payment has not been. So ইয়াত আগৰখিনি লিখি
The
দিব।
second installment of
আগৰখিনি লিখি তাৰপিছত লিখিব। Mr. J. The learned standing counsel of the KAAC submits that out of the admitted submits that the petitioners and that the respondents duly admits that the petitioner is entitled to the amount of rupees 10 lakhs. He further submits that out of the amount of rupees 10 lakhs, 50,000 has already been paid to the petitioner, and the remaining amount of rupees 9,50,000 would be paid when the adequate funds are made available. In that regard, he has placed before this court an instructions so issued by the Secretary, Department of Health and Family Welfare, Karbi Anglong Autonomous Council, along with the document, along with the communication dated 21/8/2025, issued by the Joint Director of Health Service, Karbi Anglong, to the Secretary, Health and Family Welfare Department, Karbi Anglong Autonomous Council. All these documents are kept on record and marked with the letter X. Taking into account the above, it is Soima. That 9,50,000 having been admitted, we paid within a period of 6 months from the date that a copy is served upon the respondent number. Secretary?
Secretary is not a party, principal secretary is the party.
I give it to the this was 3.
3, my lord.
3 or 5. Let us give it to 5.
Joint director, my lord.
5. 6 months.
May I take your lordship, matter is already complied for. We have received a amount. Matter
You are
will
the
be closed.
petitioner?
Yes, sir.
Come this side. This is I am seeing.
Sorry.
You practice here
Yes, that's it.
or Nagaland? Then in Nagaland, it happens like this. That's nothing. The counsel, Miss So-and-so, appearing on behalf of the petitioner. You are, what is your name?
S. Mary.
Miss Smiti, the learned counsel appearing on behalf of the petitioner, submits that the order dated 7/3/2019 in WPC number.
And WPC number. No, that's what I did.
Well, it is 8204/2018.
8204/2018 have been duly complied with. So taking into account the above, nothing remains in the instant proceedings for which the present contempt proceedings stands dropped. Mr. D. Nath appears on behalf of the respondent number
1.
one, and Mr. Simon appears on behalf of
That's why I have your 30 million.
respondent number three. Affidavit has to be filed by the respondent.
No, we have already.
There. Why will not file affidavits?
Our affidavit is ready only, my lord. If they implement the new incumbent, we'll file it, my lord, immediately.
Mr. I. Botako, appearing on behalf of the respondent contender, submits that in a week's time, the affidavit would be filed. To establish the map again on 22nd of September 2025.
Lordship in 44 Lordship budget has been sanctioned, Lordship, it will be paid within month. Within a month, it will be paid, Lordship.
Mr. S.S. Roy, the learned counsel, submits that the budget has already been sanctioned and the amount would be paid within a period of 1 month. List this matter again on 24th of September 2025 for an update.
26 within 1 or 2 weeks, it will, FOC has been.
Within 1 and 2 weeks, 20.
Let it
Which
become
one?
along with
46?
Lordship. Let it become 45 along with the 44 Lordship, because these
Here
are
also Ekma Bulli Rakhi, next date to deliver 24th.
Lordship.
46.
You are appearing, Mr.
Lordship.
Service is complete.
Lordship, complete Lordship.
Why haven't you complied?
Lordship, already on 28 May 2025, Lordship, after discussing the entire matter, Lordship, and logical conclusion, Lordship, the director sent the matter, sent everything.
Of writing a judgment, where is this?
Yes, Lordship, it is.
What is this matter about a court modification?
Lordship, page 46 is the.
He shall make the impugn action on the part of to cancel the tender and to go for price and is on the face of it arbitrary unreasonable. The decision here to cancel the tender process of where to go for fresh tender as result is interfered with. Directed to being the tender is initiated by notified in logical council and he
46 is the relevant portion, Lordship. It is directed that to bring the tender process initiated by
to a logical conclusion.
Yes, Lordship. Already, Lordship, from the part of the director, Lordship, it was discussed, Lordship, the process completed, and for advice, Lordship, it is sent to the Commissioner Secretary, Lordship. Now, the status of the Commissioner Secretary is not with me, Lordship, but he is not as in contemptor here, Lordship, Commissioner Secretary, Lordship. And moreover, Lordship, at this stage, during this time, Lordship, the director was transferred, a new director was kept.
Okay. Mr. J.K. Goswami, the learned counsel, submits that in pursuance to the directions passed by this court, dated
it is 13
2025.
30/02/2025. 30/02/2025.
But 30/02.
No, Lordship. It is the order dated 31/07/2024.
No,
What? No, my order, are you not taking up this matter?
Lordship.
Page
4
30.
2020.
4/2025. Passing application number 3832/2024. The correspondent contender have already initiated the process. And for bringing the notice inviting tender dated 13/2/2024 to a logical conclusion in terms with the said notice inviting tender. However, the said have been placed before, was placed before the respondent, placed to the learned counsel further submits that the steps that, however, the Commissioner and Secretary Assam is yet to take a decision on the proposals for submitted.
That instruction is not with me because he is not the contender here, Lordship.
I am not asking you.
Lordship.
What is your stand? Has he taken a decision or not?
No, perhaps not, Lordship.
So he has not taken any decision.
Any information was not given to the director, Lordship. Regarding that, Lordship, the director, the contemptor has no.
So, normally it should have been intimated
Yes,
to the
Lordship.
director.
Yes, Lordship.
Not yet, the Commissioner and Secretary Assam have not, to the information of the contemptor, have not taken any decision to the information of the contemptor. So in that regard, he has placed before this court and communication dated 28/5/2025 issued to the Commissioner and Secretary, Assam Animal, what is that? Assam?
Animal husbandry.
The Animal Husbandry and Veterinary Department. The said communication is kept on record and marked with the letter X. Miss So-and-so, the learned counsel appearing on behalf of the petitioner, submits that she needs some time for filing an application for including the present Commissioner and Secretary, Assam Animal Husbandry
And Veterinary Department.
Full taking into account the above,
Was it 22?
22. Taking into account the above, lists this matter on 15th of October 2025. In the meantime, liberty given to the petitioner to take appropriate steps. What do you have to do?
Lordship.
This annexure X, a copy, you take it from them and then issue a notice and bring that order. And issue a notice, kindly comply. If you don't comply, we are filing. Then give them 15 days. After that, you file this petition again. Then we implead.
Lordship, Lordship, that transfer, a new.
I know what is to it. Transfer it hardly matter.
Lordship.
And if it is being transferred, madam, you do one thing.
Lordship. Kindly be recorded. New director came, sir.
Who is now the director?
Yes, Jayanta Kumar Goswami, Lordship.
Okay, you take this, madam. You also issue him also notice.
No, sir. Kindly recorded.
Then things will move. Learned advocate entered appearance on behalf of the sole respondent. Who is it? 47.
7, my lord. I have received my instruction, Lordship, allowed 3 weeks time to file my affidavit, my lord.
Huh? So what's up? Then in spite of the passage of more than a year has passed, no steps have been taken. Have you verified or not?
No, it has been verified, my lord. The amount has, verification is
Have
there.
you paid or not then?
No, amount has not come from the government. There are 28 point some crores that amount moment comes.
We are not concerned with that.
No, let me file the affidavit, my lord.
No, that means it is a case of contempt.
No, let me find the affidavit. Lordship, let it come on record, my lord. Lordship,
You have to purge the contempt. That is the law. No, this is the very serious.
let my affidavit come on record, my lord. Second, first time appearing after the notice.
Hello. Next week?
2 weeks, Lordship, at least.
Okay. Mr. Esbora appearing on behalf of the respondent contender submits that within 2 weeks, the affidavit would be filed. List this matter on 19th of September 2025. Affidavit be filed by 15th of September. But notice is yet to be issued upon respondent number 5, 6, and 7.
My lord. Instruction was called for, my lord.
What has happened?
Lordship, may kindly have page number 22, my lord.
Yes.
Page number?
22 of the petition, my lord.
Yes.
It's a vernacular, I'm reading, my lord. Serial number 13. সকলো বজাৰ ঘাট so and so ক্ষেত্ৰত বিগত 3টা বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰাৰ সৰ্বোচ্চ নিবিদাহে
Yes, I know.
Yes. Now, my lord, what happened, my lord? Lordship may kindly have this comparative statement. And last one submission, my lord. This market was on the last year was first time no NIT was issued. Before that, it was not settled. Therefore, last 3 years there was no amount.
Then
so therefore, my lord, they did, my lord, the government value, on government value, they have 10% accepted, my lord.
Then
As
why
per
you have rejected one?
only one was, my lord, valid. others were rejected. And the writ petitioner was second last highest bidder.
Then how did you apply that?
My lord, my lord, there are two things.
No, you could not, that was practically not possible.
Yes.
If not possible, my lord.
The condition and this NIT was not there, how could you have done that?
In that case, my lord, my second argument will be, my lord. In that case, petitioner was second lowest highest bidder, my
So
lord.
give it to the top one.
That is why writ
What
petition.
else maybe?
Yes,
What is it?
my lord, I suggested, my lord.
PNRD, and you say that you don't have money.
My lord, may I submit?
this is
May I
the-
submit, my lord?
You see, one has to be fair. On one hand, just now I have taken up one matter, I vacated the interim order, taking into account that the government's right, government needs to have these finances which are there. I'm not saying, but to give it to an ineligible. But when this clause 12 did not have any relation here in this present dispute, how on earth would you have only given to those person who has quoted 1,34,000 and not given to 9,550,000 or 5,55,000 or 3,99,000 or even 2,99,000?
My lord,
What is the basis?
may I submit? I was supposed to suggest that only, my lord. The problem, my lord, I was actually suggested my client to withdraw. But after the formation of the newly elected body, my lord, the officials cannot withdraw directly. So lordship may interrupt with this, my lord, order, my lord. Then we will place before the committee, my lord.
My lord.
Lordship may observe lordship's observation, my lord. They will accordingly do that, my lord. As the last 3 years, the market was not settled. They
Yes.
wrongly interpreted with the government value.
This is Park, not market. Park.
Same, my lord. The Parkat, my lord. But this petitioner does not have any locus because he is the second lowest bidder.
No.
Maybe top 9 lakhs we can give, my lord.
No, you have to, do it and you go for a fresh tender, maybe.
Yes, my lord. That also.
You may have to go for a fresh tender.
Yes.
But the problem is the service of, what about the respondent number 7?
That I don't know.
Whom it has been given.
Yes, 7, there is no
Place
direction to take
instruction
service.
provided respondent number 8 has been granted the settlement at the lower rate than that of the petitioner by demand. Then
Moreover, my lord, clause 13.
the problem is without the respondent number 8 being there, have you made the service? This court have not issued notice, na?
Yes, my
Okay,
lord.
okay.
Not issued to a service.
Okay, and now when did you issue the work order?
Yeah, settlement was given, my lord, on
37.
37.
At that time, my lord, the elected body was not there. Now, standing committee
You can only state.
or lordship may dispose it of, my
How
lord.
will I do it? Tell me the other side is not there, na? I have not.
That is
issued
also a
notice.
problem, my lord. Yes.
That will be a.
Lordship may observe the department directly, they will run, my lord.
Huh?
Yes, that can be done, my lord. Yes.
My lord.
But petitioner doesn't have any locus, my lord, because
No,
other highest bidders are there.
Petitioner may not have, but petitioner has a better right than the other, than the 8. Others may not have come. It's a different thing. They may not take.
That does not mean I am not able to come. I am not eligible to come.
Issue notice returnable. Issue notice upon the respondent numbers 5, 6, and 8, making it returnable on 22nd of September 2025. Petitioner is directed to effect service upon the said respondents by way of the C routed through the registry of court and file an affidavit of service on or before the next date. In addition to that, the petitioner is also directed to take steps by way of registered as well as usual within 3 days. As regards the respondent numbers 1 to 4 and 7, Mr. S. duly appears before this court and have placed before this court the comparative chart on the basis of which the respondent number 8 was granted the settlement by the respondent number 7. It is seen that the respondent number 8's bid value was rupees 1,34,167. In respect to the Parghat in question.
Yes.
However, there are other bidders who have quoted much higher rate. Mr. Asdotto submits that it appears that on a wrong interpretation of
Clause 13.
clause 13, na?
Yes, ma'am.
Clause 12,
13.
clause 13 of the notice inviting of the tender notice, these steps were being taken in as much as clause 13 could not have been applied in respect to the Parghat in question, in as much as the said Parghat was not settled
Yes.
for the last 3 years.
3 years.
Earlier. First, taking into account the comparative statement, it is the opinion of this court that the allotment of the market, Parghat, that is Mulberry,
Balasar, Matragala Parghat.
Balachor, Motgola,
Matra-
Parghat, Motragola Parghat, for the year 2025-26 by the order dated 37/2025 is required to be stayed. Accordingly, the impugn order dated 37/2025 issued to accordingly the settlement of Mulberry, Balashor, Matgarla, Parghat settled with the respondent number 8 by the respondent number 7 by the order dated 37/2025 is stayed till the next date. Full stop. It is observed that pending disposal of the writ petition, it shall not be a bar on the part of the respondent authorities to revisit
Yes, ma'am.
the allotment, the settlement so made in respect to a Parghat Kano Namtu, in as much as apparently clause 13 of the tender notice would not apply in the present case.
My lord.
Full stop. It is further observed that during this pendency, till the next day, if the said markets, the said pargats
Parghat.
shall be run through in terms with 105
105.
of the
Oh,
Assam
yes,
Panchayat
yes.
Act, keeping public interest at the forefront.
One copy of CS, my lord, can it be?
Yeah, I got it. The CS, let it be kept on report.
My lord, it's not 105, my lord.
Huh?
105 is for market, my lord.
What is this?
I'm telling you.
The comparative statement is kept on record and marked.
So the CS for 2 weeks. Huh?
105 is for only market.
Yes, Huts, my lord. 106.
106.
Parghat is 106.
106. Very good.
I'm seeking on photocopy of CS, my lord.
Correction, 48, 55, very good. Yes, since all the responses are delivered, the matter is verified, but no post title has been submitted by the petitioner advocate for deleting the name of the.
My lord, can I get one photocopy of CS, my lord?
You don't have.
My lord, I only have.
I have a photostat, so did you?
Master, please.
Highly obliged, my lord.